The House is resumed for the extended sitting. I call on Government Order of the Day number 1.
Responding to Abuse and Care Legislation Amendment Bill, Committee stage.
I declare the House in committee for consideration of the Responding to Abuse and Care Legislation Amendment Bill.
Members, the House is in committee on the Responding to Abuse and Care Legislation Amendment Bill. We first come to Part 1. Part 1 is the debate on clauses 3 to 10, amendments to Children's Act 2014 and Schedule 1. The question is that Part 1 stand apart. Honourable Erica Stanford.
Thank you, Madam Chair. The Responding to Abuse and Care Legislation Amendment Bill marks a very important process in the Crown's response to the Royal Commission inquiry into historical abuse in state care and in the care of faith-based institutions. This bill was introduced to Parliament on the 12th of November 2024, the same day the Crown made its historic public apology to survivors of abuse and care. The changes in this bill, Madam Chair, are another step forward in the Crown's response to the Royal Commission, making an important start on changes to improve the safety and well-being of children, young people and adults in care. I just want to start by thanking the survivors who made submissions on this bill for your bravery in coming forward and helping to make the care system better for others. Thank you to the Social Services and Community Select Committee for your significant improvements to the bill. This is an omnibus bill. It makes improvements to 4 acts. Under the standing orders, where a bill is drafted in parts, we will consider it obviously part by part. And as the Minister responsible, each Minister responsible will talk to the relevant part. So I will lead Part 1 on the amendments to the Children's Act 2014, which falls into my portfolio responsibilities as a Minister of Education, before handing over to my colleagues, Minister of Justice for Part 2. Minister of Children will lead Part 3 and associated schedules, and I believe that the Minister for Children will also be looking after Part 4 as well today. The 2 changes in the Children's Act will help keep children safe by strengthening provisions relating to core children's workers with certain types of criminal convictions. So the changes, Madam Chair, are extending the workforce restriction for core children's workers to include overseas convictions for offences that are equivalent to specified offences, and adding offences involving minors in the Prostitution Reform Act to the list of specified offences that trigger the workforce restriction. Madam Chair, the first change to the Children's Act addresses a gap relating to children's core workers with convictions for serious offences overseas. So it's unlawful to employ someone as a core children's worker if they've been convicted of a specified offence and do not have an exemption. The specified offences are listed in the Children's Act. They are offences under the New Zealand law involving serious harm, including harm to children, but they currently do not cover overseas convictions. This change will make it lawful to employ a person with an overseas conviction for an offence equivalent to a specified offence in New Zealand as a core children's worker, unless they have an exemption. Exemptions enable a person to still be employed if they would not pose undue risk to the safety of children. Individuals with overseas convictions will be able to access review and appeal rights when a decision is made about the equivalency of convictions. Madam Chair, the second change adds offences involving minors under the Prostitution Reform Act to the list of specified offences. These are offences under the New Zealand law involving serious harm, including harm to children. This will make it unlawful to employ a person with a conviction for one of these offences as a core children's worker without an exemption. These changes will help to close known gaps in the protections in place to reduce the risk of harm to children by employing people employed to look after them. Guidance will be made available to support employers of core children's workers to understand and comply with the changes. This work is well aligned with the Royal Commission's findings and recommendations in relation to screening and vetting of workers. The feedback on the changes during the Select Committee phases were largely supportive. A common theme throughout the Select Committee process was that the changes were positive, but that we could do more to improve child safety, for example, through further amendments to the Children's Act, which we will consider. The amendments are a first step. Cabinet has directed further work on options for improved children's worker safety checking requirements, and the Ministry of Education is leading that work. In addition, through Budget 25, the government invested up to $71.5 million to build a capable and safe care workforce for children and adults across the care system, and agencies are working on a joint approach which will include consideration of any changes needed to strengthen the workforce safety further.
Helen
Chair.
White.
Thank you, Madam Chair. First of all, I just want to acknowledge the people who have suffered under a law that has not protected them for many years, and it is something that we can never really say enough about, and Labor is supporting these changes because they're a first step, but we are absolutely committed to a much more comprehensive response to what has been an appalling practice in New Zealand, and the apologies that came out of the government were very much an acknowledgement of that, but my own personal concern is that we still have many children who are not being protected sufficiently in New Zealand, and we have a continuing issue. So I acknowledge that this piece of legislation is a start in that direction, and while there have been many concerns raised by the community and concerns raised by other parties as well, in support of a community that is worried that it has not been consulted sufficiently, we will be supporting the changes so far as they go today. I just wanted to talk about the nature of the changes in an overarching way. We have changes to the Children's Act, the Crimes Act, the Oranga Tamariki Act, and also changes to the Public Records Act here. And what we have is a change to one that's maybe the most controversial is the issue over search plans, and that will be looked at today, and no doubt there'll be questions asked of the Minister about that. I think we're all in agreement in terms of the movement to look at convictions overseas and that gap. That's a really important gap, and I was recently in Australia at the Women's Shelters Conference, and Australia's doing a lot of work in its children's safety plans to really make sure that in every state information is being passed and people are not able to move from state to state. It made me reflect that we're very lucky here. We have a small country, and it's quite possible for us to close that gap, and that overseas convictions gap was really that one. We don't have the same complexity as people who can move from state to state. So we're in a pretty lucky position in that way, but we have had an issue in this area, and so that is something that I think we can all support in this House. I'm also really interested in the changes to care record access and transparency, and the interest in public records. Again, I have been concerned that in places like Canada, while there have been these commissions that have looked at these very similar issues with Indigenous populations, for example, being hurt, there is often a lack of transparency over what has happened and a lack of power and kept by the people who have been hurt. So I think these changes, while they don't probably look to the public like they're important, are important changes where we make sure that our public record system is acting on behalf of the people impacted, not protecting others in the system. So I think those ones are underestimated in their importance and the value of keeping going. So I'd like, sorry, I've just got a few seconds. I would just like to start with a question about the impact on the issue about survivors and their involvement in this process, because that's been raised by several parties that there hasn't been enough, and it's a concern that the Labour Party has had too, that there hasn't been the consultation that has been expected. And when you have that kind of low trust of people who are deeply traumatised, that seems something where we could do better. Why has there not been the consultation, and what plans are there to
Helen
consult?
White.
Thank you, Madam Chair. So I'll just put that one question to you. I do have other questions, but could we start with that, because there'll be people watching today who have been impacted by this, and they have expressed a concern that they have not been consulted sufficiently. One example of that was the issue over disability and vulnerability and its inclusion that has come to light. So could we talk about why did we make the choice to go the way we did, or why did the government make that choice, and what will happen from now on in terms of opening that consultation? Does the Minister concede that perhaps we can do better in the future iterations and changes to respond to this abuse inquiry? So can I know about that first? Thank you, Madam Chair.
Timothy Paul.
Morena kia koutou mori ora ki te whare. Tuatahi ki ngā morihu o te motu. Tēnei te mihi nui kia koutou. Ngā mihi aroha kia koutou. Mō o koutou kaha, mō o koutou whawhai tonu. Ki te meneta, Morena, we're obviously supporting this bill because of all of the work that has gone into it, from survivors, from people from all different parts of society and of the community. So our contributions in this committee of the whole House are really an attempt to try and understand particular parts of the bill that survivors have brought up that need to be scrutinised, and that scrutiny is deserving, because we know that one of the reasons why the scale of abuse of children, the scale of torture, the scale of violence took place between the years of 1975 and 1999 because of a lack of institutional safeguards, because of a lack of children's safety and indeed children's rights being put at the forefront of legislation and of all of the rules and conditions around that state care. And we know that some of the other contributors to that horrendous abuse that took place in state care and in faith-based institution was also a consequence of having untrained staff members, a lack of institutional safeguards, a lack of safe regulations, and also the location that some of these institutions were at. For example, Great Barrier Island or Aotearoa in 1970s during the Whakapakari boot camp. So our question to start off in terms of part one are similar to Helen White's questions to start off, and it's really to understand how survivors have been involved in this process and how, since the first reading of this bill, has the government listened to that feedback from survivors. We all would have received lots of emails from survivors, whether they're part of an advocacy organisation who are doing that work on behalf of survivors, or you might have heard from individuals who have reached out to us. And I guess to summarise what our inquiries will be about today, we're really interested in the use of force and how that has been safeguarded, and wanting to ensure that that is a last resort and that all other options have been exhausted before we get to use of force. Sure, there's no problem in breaching what we're going to be talking about today so that this is a productive session. So we're in part one, nothing's changing in part one. I'm just letting the Minister know what our areas of inquiries will be. So I'm interested in the use of force. I'm interested to know how survivors have been involved in this whole process. We're interested to understand secure care and young people and how long they are allowed to be legally within that secure care. And there are other areas in terms of youth justice residences and state care institutions that we're keen to breach. But firstly, keen to start off with how have survivors been incorporated meaningfully into leading us to the bill we have in front of us today?
Honourable Erica Stanford.
Thank you, Madam Chair. Look, and just in relation to the similar questions asked around consultation in relation to my part of the bill, remembering this bill was a bill that we introduced a year ago in response to the Royal Commission, which undertook extensive consultation. So we had a 6-year process which raised some of these issues. This also seems to be an issue that has been known for some time and not dealt with, and when I became the Minister it was something I realised we needed to deal with, not only through the Royal Commission but something that seems to have been known and not dealt with for many years, as far as I can tell. So, first thing, we had a Royal Commission for 6 years, very clear in their recommendations. This bill responds to that. Secondly, we had, it's been a year, we've had a select committee process. People have been able to have their views heard. We've taken those into account. This part of the bill was relatively uncontroversial. We didn't have many, hardly anyone, in fact, I believe, say anything about this part of the bill that meant that they were opposed to it. So widely supported, relatively straightforward change, fills a known gap, responds to the Royal Commission report. Many people are involved in that, but more broadly, and I have set up a ministerial advisory group of representative survivors to help guide the government in its work over the next few years.
Glenn Bennett.
I could, Madam Chair. Firstly, just can we ask if that microphone can be just slightly tilted, well, when you're standing up, sorry, more towards you when you're standing up, just to hear properly. Thank you. That was
Okay, I'll watch.
Thank you. Thank you, thank you, Minister, for being in the chair, and as has been addressed by colleagues already this morning, this is around acknowledging survivors, those who are still with us and those who have passed, and we acknowledge them this morning and throughout this process. I also want to acknowledge last night in this House, or last night in Parliament, and we celebrated 50 years of the Waitangi Tribunal and I guess the significance that holds in the space we stand in today, and as we talk about abuse in state and faith-based care. And my simple question to the Minister this morning, following what you've just said, is there has been a 6-year process, and survivors have been a part of that all the way through. We understand there's a ministry advisory group that survivors are part of. But I guess my question is to the Minister just around trust, and how can in terms of where we're sitting in this part of the legislation, in terms of, trust has been broken, trust has, the state and faith-based organisations have breached that trust for many, many years. And so my question to the Minister is, are you confident we have landed in this part of legislation that survivors can trust that you have lent in, that you have listened, and that you've taken on board what they want? And as we continue to move through the morning, and as this processes through the committee stage and then into the third reading, the fact that survivors and families can actually trust you as a minister, and I mean that in a genuine way, in terms of that they are on board and they are every word that's in this legislation, that they can trust that you have listened and will continue to listen, and if anything does need to change, then there is openness to that.
Helen White.
Thank you. I have a quite specific question, which is about the responsiveness of Part 1 to new offences. I know that we're moving, hopefully, to a law where we change the rules around trafficking, and they're quite a significant change, and I really welcome the work done in that area, where we move away from consent. So for the public, that means that we're looking at children who might be enticed into exploitative behaviour, perhaps with offers of gifts, etc. And the issue, and in fact even adults in that situation, so sort of organised exploitation of people. And I can see that we talk about specified offences. I'd be really keen to know from the Minister, with that kind of law change in the wind, which I really welcome, is that wide enough? Is it that there's a regulation where, in fact, specified offences can be added to, and that would mean that somebody involved in those kinds of activities, which in the past have not come into offences, would be captured, and that is a worldwide phenomenon. So those law changes hopefully are happening as we recognise that kind of behaviour internationally. So while we're doing it here, we're also following a trend overseas. So I'd be really keen to know what is the Minister's plan with regard to offences here and offences overseas as our recognition of inappropriate behaviour hopefully changes for the better. How are we capturing that? Thank you.
Erica Stanford.
Madam Chair, I think it's already clear in this bill that we are adding specified offences, as I mentioned in my opening speech. So it's very clear that as things come up, we will consider adding them to the specified offences list, as we've done in this bill today.
Timothy Paul.
Kia ora, Minister. Thanks for your answers before as well. Really appreciate you illuminating some of these issues for us. I'm keen to ask another more of an overarching question, just because I understand that Minister Stanford is here with us for part one, and then we're moving to a different minister for part two. So this question is about kind of the broad thrust of the bill, but there are parts relevant in part one, and it's the fact that in Whanaketia, the actual report that came out, there were a number of different recommendations made, and some of those span across this entire bill, including within part one. And I guess some of the big feedback that we've gotten from Morehu is why they want to understand why some recommendations have been implemented in this bill and why some have not been implemented into this bill. So I'm really keen to get an answer from the Minister in charge of the inquiry and the follow through of those recommendations to maybe talk to the House a little bit about why some provisions that were called for weren't followed through with. One of the main ones that we hear about is the request for an independent survivor-led redress system. But I understand that there were other recommendations that haven't been followed through. So, yeah, my quick question to the Minister is, what was your decision-making process when you were going through those recommendations, and how did you choose which ones you would implement through this bill and which ones you weren't able to?
Madam Chair,
Erica Stanford.
as I already said in my opening speech, this was a bill that we introduced a year ago. It was the very first piece of legislation. There is an enormous amount of work to do. There are hundreds of recommendations that need to be looked at, considered and enacted potentially, and we're going through that work. Budget 25 funded a safe and capable workforce, for example, and there will be an enormous amount of work to do there, including lots of consultation to get that right. So, huge piece of work. This was the piece of work that we knew we could do quickly, identify known gaps and move on with it and make meaningful change, so we could say to survivors, we are listening, we hear you, we want to get something underway as quickly as we can where there are known gaps in the system. This is this piece of legislation, but since then there has been an enormous amount of work and a huge budget injection to make sure that we will continue this work.
I'm going to take a call from Helen White, but what I'm going to ask for now is, we've had a good, respectful way of setting the scene this morning. I'd like people now to refer to clauses specifically to part one.
Okay, thank you. Although my wish when I stood up was to just look at this issue about the consultation, because I don't think it's been addressed yet, and to explain. So this is an issue about how we got to part one and this priority list.
I actually have been listening to the Minister's answers, and she did talk about the inquiry in the Select Committee and the consultation and the opportunities. So I feel like we've covered that, and I'd like questions related to specific clauses now, please.
Thank you. I think that we are in agreement largely with part one, and I don't want to waste time with things that we actually agree with. So I think that we probably can just leave it there on that. I don't think that's a problem. Thank you.
Hamish Campbell.
I move that debate on this question now close.
Glenn Bennett, do you have a specific?
I do, Madam Chair, thank you. And I think it is, I think it is to do due diligence is to actually to spend a little bit more time because people are listening and wanting to make sure that we are held accountable. I'm looking at clause 28C, obviously in terms of the review process. So it talks about going to the chief executive, the process of doing that in terms of a survivor being able to ask questions. But I want to come through to 28D2, which the applicant may, so if they want to appeal against the decision that's been made by the chief executive, that 28D2 says the applicant may appeal to the High Court against the decision to confirm the determination. Now, it's really just a question about cost, and I haven't actually been on the Select Committee, so forgive me if it is answered somewhere else, but in terms of a survivor going through the process, they will be able to apply, they'll be able to go to the Chief Executive, but then in terms of, again, the support for a survivor who has been through trauma, who has been harmed and hurt by the state, and then the state then requiring them to potentially pay to have their appeal heard by the High Court. So I'd appreciate for that to be illuminated, understand a bit more about, again, for a survivor, who is paying the cost when they've already paid the highest cost.
Vanushi Walt. Oh, sorry. Honourable Erica Stemford.
Thank you, Madam Chair. Just to be clear, this part already exists in the legislation for core workers who have a conviction in New Zealand. We're just aligning the law so that people who have an overseas conviction and now fall under this piece of legislation also have an appeal right. So this is not about survivors having appeal rights. This is about the core worker having an appeal right against not being able to work.
Vanushi Walters.
Thank you, Madam Chair, and thank you to the Minister for her responses thus far on this piece of legislation. I do agree that it's a missed opportunity, and just a general comment, and then I'll speak to a few of the specific clauses. I attended a conference last week on the Bill of Rights Act and met several of the lawyers working in this area, and a comment on repeat was around the Limitations Act, and whether consideration had been given in terms of that very key limitation on people being able to access their rights of complaint, which was six years, I understand. So just a general comment. In terms of section 28A, I just had a question about the interaction between a determination under 28 and name suppression provisions. So what consideration there is when a determination is made under the new section 28 and there's a clear indication that there will be an application for review, and this may tie into separate legislation, but just curious about whether there may be name suppression issues in that. On 28B, new section 28B2, there is a reference to a chief executive receiving an application and the ability to hand that application for review on to another chief executive. And just a question about the rationale for that and when it would be used. Subsection 3, there is a reference to the chief executive confirming whether the applicant has previously applied for a review under the section before making a determination. So obviously a separate ask, and just a general question about the rationale for the chief executive to need that information before making a decision on the application in front of them. Thank you.
Tamitha Paul.
Thank you, Madam Chair. Okay, to get specific, my questions are around the amended section 28, which talks about core workers. So core workers convicted of specified offences not to be employed or engaged. And I guess my questions are around the word core, because obviously if we're looking at a youth justice residence or a care institution, or if we're even looking at third-party providers that might provide a training or a course or something to the young people in either of these institutions, I want to understand what core worker means and why we've only focused in on core workers. Does that mean that other workers that are working in and around children are able to have convictions of these specified offences within the Act? Does this go far enough to provide the kind of institutional safeguards that are required of the adults who are meant to be caring for and looking after young people in these institutions? But I just think it's interesting that there is that use of the word core worker. What does that mean for other people who are engaged? I'm thinking of there might be, say, trained youth workers or social workers, but they might have people who are supporting or volunteering in an organisation, like a third-party provider, whatever. There's lots of people around, and my assumption would be, after the scale of abuse and torture that was experienced for decades and in some ways still endures today, how much of that abuse took place by people who are just simply around and had the ability to be around, and do we expect the same requirements of them to not have offences that make them a danger or a risk to be around children, particularly really vulnerable children? So yeah, seeking to understand why we've specified that only core workers must not be engaged or employed in this business, and what safeguards are in place to make sure that every person that interacts with, guides, teachers, interacts in any way, small or big, with vulnerable children are not going to pose any danger or risk to their well-being and safety.
Honourable Erica Stanford.
Thank you, Madam Chair. And in response to that member's question, the core worker is an existing term defined in the Act. Specified offences only apply to core workers for restriction. So the key is that when people are working with children and have unsupervised access to children, they are teachers and learning support people and teacher aides and those types of people who generally have unrestricted access to children that we need to protect children from. And that's why we had this known gap, and that's why it's being closed. Madam Speaker, just in relation to some of the other questions, the Limitations Act is outside of the scope of the bill, I've been advised. The Chief Executive can hand over review if the work of the person is more relevant to the other CE's sector, which makes sense. And in terms of the no repeat reviews, we don't want the worker to keep applying for a review for the same offence.
Madam Chair.
Suze Redmayne.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumā whānga pōti e whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 53. The question is agreed. The question is that part 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Members, we now come to part 2. Part 2 is the debate on clauses 11 and 12, the amendments to the Crimes Act 1961. The question is that part 2 stand part. Honourable Erica Stanford.
Madam Chair, I'm expecting my colleague to come down and take most of these questions, but I just want to open with one of the things in the select committee process that I know that there was a huge amount of debate over it, because the bill amends the Crimes Act 1961 to add disability to the definition of vulnerable adult in section 2(1) of the Act. This is a direct response to the recommendation 26 of the Royal Commission's final report, so a direct response to the Royal Commission's report, which states that the government should amend the Crimes Act 1961 to specifically include disability within the definition of a vulnerable adult. The amendment does not expand the scope of what's captured by the definition of vulnerable adult. It's a classification rather than change to the effect of the law. Look, during the Select Committee process, Madam Chair, the Ministry of Justice recommended in the departmental report that the words at risk be added alongside vulnerable in the definition of vulnerable adult. However, Parliamentary Counsel Office, PCO, suggested that doing so would carry the risk of unintended consequences to the underlying definition of the vulnerable adult. As a result, the Ministry recommended withdrawing this recommendation and retaining the original amendment as proposed by the Royal Commission themselves. As I say, this was a direct a response to their recommendation. And I know that it has caused some disquiet in the community, and we are very sensitive to that, but the word vulnerable in this instance has a definition, has meaning, and it was a recommendation by the Royal Commission after 6 years of their report, and we are responding to that. But I think, as you can see, we did try to, and I know the Select Committee, and thank you to those of you who were on the Select Committee, did try and come up with solutions to help solve this problem, but in the end we ended up back in a position, as recommended by the officials, that this was the best course of action in responding directly to the Royal Commission's advice.
Helen White.
Thank you. The Minister is absolutely addressing an issue that I'd like to take further, because this was perhaps something that was the most passionate response that was given on this area. Just for the benefit of the public, we had a lot of submissions, and I wasn't on the Select Committee at the time, but I have had approaches about this very issue. There was a lot of people who considered the words inappropriate, and what they wanted was a replacement of adult at risk. And I continue to think that it's incredibly important that it is not, it is something that we never dismiss, this actual on-the-ground experience because of the trauma involved. So I appreciate that the Minister has given an explanation that we've gone back to what the Commission has suggested, but the very purpose of a submission process is that we listen to the New Zealand public and we listen to those voices, and I, for one, think it's one of the best things about our system that we do, is we listen very clearly to those voices in our process, and that we respond to those often by changing where we're going. So I would like to know whether the Minister would consider...
Can I just interrupt the member, and just because we're changing ministers, could you just set that scene again?
Yes,
for the question
sorry,
that
I
you're
will.
asking, just so we're clear.
Thank you very much. Good morning to the Minister and the Chair. What we are talking about here is part 2, and we're talking about the significance of the use of the words vulnerable adult and the potential replacement of those words with adult at risk. And while I acknowledge that the last Minister and the Chair explained that what has been done here is to continue with the language that was proposed by the Commission itself, I was explaining that one of the best things I think about the New Zealand democratic system is the force of us listening very genuinely to submissions in select committees, and this was a submission that was made repeatedly and very articulately by people who had suffered this trauma or and had thought very deeply about these issues. So the preference from many of those people was to swap out the use of the words vulnerable adult with adult at risk, and it seems to me something that we really could do, but I would like the Minister's explanation as to whether he would entertain a change of language there by amendment, and I could put an amendment on the table doing that. The Select Committee rejected the suggestion out of concern for what it was seen as unintended consequences. If the Minister for the people who are listening, who actually made those submissions, and they will be listening today because this is something so close to people's hearts, if the Minister could explain what specifically some of those unintended consequences that the majority of the Select Committee were worried about are or were. So I'd really like to drill down here, because I am conscious that it is really, really important we respond to the Select Committee, and it's related to an earlier point made right at the commencement of this committee stage, where we were really talking about the concern over the lack of consultation. So the one thing that I think has been done well is the Select Committee process, and this is what the people said. So it's a really heavy thing not to listen to it. And I just wanted to emphasise that in an area of great trauma for people that's very real and absolutely rests and was a responsibility of the state, listening to people at this point builds trust, and that trust starts at an all-time low. So listening, in this case, saying on the, Madam Chair?
Helen White.
Sorry, I won't take too much more of your time, but listening and responding here today to this suggestion by altering the language or accommodating the worries of the people involved in this process would actually be its own step in terms of trust, rather than overriding it with something that can be seen as an institutional override. So can I have an explanation as to what the fear was of unintended consequences of using the alternative language? And can I have an explanation of whether the Minister would consider swapping out the language or including the language as the other way to go, perhaps, having both those parts of language? I'd be very grateful for a proper answer on those things. Thank you.
Timothy Paul.
Thank you, and kia ora to the Minister. We have a number of questions in terms of the term disability, and again on the terms vulnerable adult and versus at-risk adult. I guess the problem that my colleague Helen White is trying to or is canvassing is that vulnerable adult, or the term vulnerable kind of suggests something inherent within somebody, almost something that you can't change or shift or shake. And so the kind of connection between vulnerable adult and having a disability kind of implies that if you are disabled, that you are a vulnerable adult. Now, I've got multiple disabilities. I've got rheumatoid arthritis, I've got lupus, I've got, but I wouldn't consider myself a vulnerable adult. And there are many people who live their lives and have disabilities who we wouldn't consider vulnerable. They're completely independent, they're capable of making their own choices, they're capable of moving around and exercising their own discretion and power in whichever way they see fit. So I guess the question we're trying to understand is, what was that decision making behind connecting, I guess, the existence of a disability and the term vulnerable adult? Because, yeah, again, that vulnerable suggests something inherent that will always be there, whereas at risk, the term at risk points to or suggests maybe the circumstances that somebody is living in that makes them vulnerable. So thinking about the children and the young people who end up in youth justice residences or end up in state care, there might be a number of factors that mean that they are at risk. It could be their home environment, it could be the town or the community that they're growing up in, it could be influences around them, like use of drugs and alcohol, violence in the home. These are things that would suggest that that young person is at risk. But if we can remove them from those environments and put them into a safer environment, that factor might be mitigated, meaning that they're not necessarily a vulnerable adult anymore. So really keen to understand, that choice to use vulnerable adult over at risk, but also that choice to connect disabilities to that definition of being a vulnerable adult. The other thing we're interested in is the term disability and how that fits into the definition. So in this country, some disabilities are treated differently to others. Some are not recognised, some come with funding, some come with better methods of diagnosis, and some disabilities have far better understanding in the health world and in the kind of children's world as well, in terms of those professionals that are working with children, but they're not all treated equally. So the example that I want to give is fetal alcohol spectrum disorder. So FASD, very prevalent in our prison population, and I would assume, based on my one visit to a youth justice residence last year to Te Punawai in Christchurch, that fetal alcohol spectrum disorder is probably prevalent in a lot of the young people in there. I know traumatic brain injuries definitely are, but things like FASD, if you're a kid with fetal alcohol spectrum disorder, you don't get access to certain types of funding. So ORS funding, ongoing resource scheme that gives that extra funding to kids in the education system with disabilities. If you've got FASD, you can't even access that. And that's not the only disability that is not recognised or funded or supported in this country. So what definition or list were you working with when you were thinking about disabilities, and is there a defined list, or would that be up to the courts to determine whether that child is disabled or not, or is there a list that you're working from, and is there a recognition that all disabilities are not treated or identified or supported evenly?
Madam Chair.
Honourable Paul Goldsmith.
Well, I thank the two speakers for their questions and their introductions. I think the first point I'd make is, of course, the government has been listening to the submissions on the Select Committee process, and that's very much our intention. It doesn't always mean that you necessarily agree with the suggestions made, but that does not equate with ignoring. It is just recognising that what we're doing here is responding to the recommendations of the Royal Commission's report, which had spent many years and had an enormous amount of consultation with the broader affected community, and their conclusion and their recommendation to us was to acknowledge concerns from the broader disability community about describing people as vulnerable, but recommended changing the Crimes Act to strengthen the protections for disabled people in the current legislative framework. And so that was the recommendation, so to include or add disability to the definition of a vulnerable adult, which is currently in the Crimes Act and is well established, has a lot of case law around it, and so that was their recommendation, and that's what we're undertaking in this legislation. If you were to change vulnerable adult to another definition, such as at risk, well, that obviously has consequences much more broadly than this particular instance, because it changes that for everything that applies in that situation in the Crimes Act, and with ramifications that may be unintended and not necessarily helpful to other elements of that regime. So we're following the recommendation of the Royal Commission. We understand that there'll be a variety of views on this, but we do take some confidence in the process of the Royal Commission and the very extended process and significant amount of consultation that went into that, to recognise that that was a sensible thing to recommend, and that's why we're carrying it through.
Haringi Carter's amendment paper number 365, deleting part 2, is out of order as being a direct negation of the question. The best course of action for any member supporting this amendment is to vote against part 2, standing part. The question is that part 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is being called for. Please, Clark.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumā whāngai pō te whakahe.
Act New Zealand.
Leave it in favour.
New Zealand
8
first.
votes in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 53. The question is agreed. Members, we now come to part 3, and this is the debate on clauses 13 to 31, amendments to Aotearoa Tamariki Act 1989 and Schedules 2 and 3. The question is that, I'll just wait for the Minister to swap because you may wish to speak first. I'll just wait for the Minister to get settled.
Thank you. Yeah, because it's not. Appreciate it. Yeah, this makes sense. Okay, as long as we're in the middle. Cool.
Yep. So the question is that part 3 stand part.
Madam Chair.
Honourable Karen Shaw.
Thank you, Madam Chair. This part of the Omnibus Bill in response to the Abuse and Care Inquiry is around the Oranga Tamariki Act. The content of this part of the bill makes 3 changes to all residences. It repeals strip searches, requires a search plan to be created, applies to all children and young people in secure residence, and it's around plans being adhered to unless not reasonably practical. It clarifies the duration in secure care, which will be 3 days before court authority is required. And this also makes 2 changes to youth justice residences. It will enable searches to entry. Everyone may be searched before they enter, with no requirement to have reasonable grounds. And it also enables the use of image technology that applies to all searches, both on entry inside a residence. Madam Chair, I've also placed an amendment paper which is looking to make changes to looking at a clause 17 of the bill, which defines terms related to the new search on entry provisions in secure youth residences. Under this clause, I'm proposing to add a definition of the word enter in relation to these searches. The definition makes it clear that a search on entry can include entering from an administration or staff building or thereof into secure area containing residential units. This means that a search can happen at the boundary of an administration or staff building, at the secure residential units where young people live, or when entering the administration building from outside of the secure residence. This flexibility is needed to accommodate infrastructure differences between residences, which can affect where a scanner can be placed. It also gives Oranga Tamariki the option to avoid searching visitors who do not go beyond the administration building. It also proposes minor and technical amendments to the bill to clarify definitions and address drafting errors. Madam Chair, this has been a long time coming. It's been spoken about for years, even before the Abuse and Care Inquiry, around safety when it comes to our young people in care, and particularly in residences, and making sure that we're listening to them and making sure that they are safe when they are in the care in a residence. So this bill is about making sure that we're keeping our young people safe, keeping our staff safe, and bringing some professionalisation into these residences that hasn't been there, to make sure that we have good oversight so that our young people can't be hurt or harmed when they are in a residence. I feel that these changes are just a small part of what we are doing within Oranga Tamariki. There's a lot of work going on in the background that doesn't require legislation, but with the help of this legislation, our youth justice and care and protection will have better tools to be able to make sure that our young people are safe. So I look forward to answering any questions.
Madam Chair.
Helen White.
Thank you, Madam Chair. I want to start looking at section 16 which is the time limits on secure care, and talk about that. I just want to open on this part by saying this is probably the part of this Act that people have been most worried about, and for good reason. It's very serious in its implications, and the actual detention and the time period is part of that, but so is obviously the invasiveness of searching and the humiliation that is involved in the control over people in that situation. But probably the most contentious bit will be the issue over force used in that situation. So I wanted just to start with this in a methodical way and focus on section 16. So what has happened in the amendment of the law and will happen is that we'll move from a continuous period of 72 hours of detention, and we'll be moving to a situation where there is clarity over the period that there hasn't been before, including the actual period commencing on the day on which the child or young person is first placed in secure care. So I would like the Minister to explain, because we will have people watching who have had this happen to them and have had this situation abused in some way. So I'd like a plain explanation of what this change is intended to do and what kinds of grey areas there have been in the past, and the concern over the previous way that this was written in the law, and why we are now in particular moving to articulating that the commencement of the period is actually at the time when the person is first placed in secure care. Had that not happened before, what were the stories that we heard in terms of when that was triggered in the previous situation? I'm only just putting this one thing so that it could be addressed. I do have obviously lots of other questions about this particular part. Thank you.
Timothy Paul.
Thank you, Madam Chair, and I'll follow in that lead around questions on Clause 16 around time limits on detention and secure care. So, and just wanted to note for the Chair that we've got a number of amendment papers that we're keen to explore, and again in the kind of good faith, good nature approach of trying to make sure we cover all our bases while passing such an important piece of legislation. So on the time limits on detention and secure care, we've got an amendment paper which reduces the 72 hours to 3 hours, mostly because we're cognizant of the psychological and physical impacts that it can have on any human being who is detained in secure care for prolonged periods of time. Obviously at the extreme end we see that quite a lot in the adult prison system, where you have reports like the report into the Prisoners of Extreme Risk Unit at Auckland Prison, where there were people in there who spent 900 consecutive days in essentially solitary confinement. But back to the youth justice residents, we're really interested to know how you landed on 72 hours as your amount of time that you're comfortable or want to legislate for young people to spend in secure care. Having spoken to people who work in YJ residences, I can understand why secure care might be, could be an option in some circumstances. It can be really overwhelming being in a residence full of other rangatahi, and maybe being in secure care gives them that time to just be alone with their thoughts and kind of regather and regulate their emotions and figure out what next, particularly in really hostile youth justice residence environments. But I think we have to be really careful that we're not leaving people and leaving children in the secure care for too long of a period of time, because when people exit that secure care eventually, if they haven't had any human or social interactions or contact for too long, it can cause even more adverse problems. It can mean that their emotions or their actions can become more aggressive or more hostile because they haven't been around other human beings, so they have to kind of ease back into that. So our questions on the 72 hours in secure care is, how did you land on 72 hours? Why was that picked to be the period of time that young people would spend in secure care? Why would a young person need to be put into secure care in the first place? So I obviously just gave some examples of that, but I think kind of illuminating why you need access to that tool in the first place could be constructive to the interrogation that we're doing today of this bill. What do those 72 hours look like? So what is that child entitled to during their time in secure care? Does it mean that they will be constantly observed during that 72 hours? Will there be someone sitting outside that cell? Let's just call it what it is, it's a cell. Will there be someone sitting outside and observing during that 72 hours? Will that young person have privacy? How often will they have meals? Are they allowed to be visited by family members or by mental health professionals or workers that work in those youth justice residences? So what does that 72 hours look like for that young person in secure care? And what else happens during that time? So is that young person given an explanation as to why they are in there? Are they given a really fair understanding of how to get out of there or how to raise concerns if they don't feel that they should be in there? To relate it to solitary confinement for adults in the correctional system, one thing that was brought to light through the Peru report that came out last year is that people who were in Peru for prolonged periods of solitary confinement had no idea either why they were in there or no idea how to get out of there or what the process was to get out of there. So if there is a young person in secure care who doesn't want to be in there, are they made aware of their rights? Are they made aware of the process to get out of there? And in terms of that 72 hours, when does that start again? So if a child spends 72 hours in there and you're like, oh, well, the law says that you've got to get out of here because it's been 72 hours, is there a period of time that they have to spend outside of secure care before they are able to go back into it again? Because we don't want, Madam Chair? We don't want there to be a system where a young person spends 72 hours in there and then they're out for like, say, 10 minutes and then they're able to be put back into it, so that you end up with these kind of long lags of secure care and kind of skirting around the legislation that is supposed to prevent that. So when does it start again? And how are they eased back into social interactions? Because again, any human being who spends a long period of time in a cell by themselves, largely by themselves, it's going to be hard for them to go back into an environment where there are lots of other people. So how are they eased back into the residence or back into the community following that security care? So just to summarise, my questions are, how did we land on 72 hours? Is that aligned with other international standards, or is that aligned with some kind of recommendations from someone like the Ombudsman or the Independent Children's Commissioner? Who set that 72 hours? Why would somebody need to be in secure care, and is it made clear to them how they can exit secure care eventually? What does that 72 hours look like? Are they being observed? What are their meals like? Are they able to be visited by professionals? When does that 72 hours start again, in terms of, is there like a grace period before they can enter secure care again? And how are they eased back into when they exit secure care, how do they ease back into the residence without being overwhelmed or aggressive or, the natural feelings that you might feel after not having human contact for 3 days in this case?
Madam Chair.
The Honourable Karen Shaw.
So I'll answer some questions around secure care and why time frame is needed. I just want to clarify, because it's been repeated a couple of times that we landed on 72-hour time frame. Actually, this legislation will be deleting the 72-hour time frame to make sure that we are very clear that it clarifies that 3 days in secure care before court authority is required is what was landed upon, not 72 hours. The problem is that when you had two separate definitions, if a child or young person was placed in secure care at 6 p.m. on a Tuesday, that is day one. So when counting 3 days, they need to be out by midnight on the Thursday, in contrast to when counting 72 hours after 6 p.m. on a Tuesday. It is 6 p.m. on a Friday, 18 hours later, than when counting 3 days. So we just want to make sure that they're not staying in secure care longer than they need to. So the 3 days just really clarifies that. If we have the 72 hours, they're staying longer. So this is just a clarification because there was a bit of a gap in that legislation where we had two different timings. So that's how we came to the 3 days, not 72 hours. And I just want to make that very, very clear that we haven't landed on that 72 hours. Just removes doubt about when court oversight is required. So the question was asked, when does that start again? Once you hit the 3 days, there needs to be court authority required if you want to continue that secure care. So that is up to the courts whether that continues. What I would say though is that the member has painted a pretty bleak picture of what secure care looks like within a youth justice residence. I just want to clarify that the young people are not withdrawn from contact with other people. They don't sit for 3 days with no contact with a person. They are in a secure care unit, which means that they have the ability to move around the unit. It is a separate unit from the unit where they may be cohorting with a group of people. They are removed from that unit with the group of other young people and moved into a secure care unit where they have the ability to move around the secure unit. They will have staff with them. They have access to their social workers if need be, and they are able to be in the day room during the day, but just within a more secure area to keep them safe, to keep the other young people safe if there's been a bit of a conflict within their unit, and to allow them time to have a conversation maybe with a worker around how we can do better with the behaviour and give them a chance to regulate themselves so that they can move back within a normal unit. So this picture of sitting in a cell with the door locked, dark and dank, and not being able to leave their room and have no contact with people for 3 days is absolutely untrue and over-exaggerated. Young people do have the ability to have conversations with workers about why they are in there, what they could do to avoid ending up in the secure care unit again, and how we can work better, even as staff members, with them to help de-escalate a situation. So I just want to make that clear. Why do we need secure care at all? Secure care is only used as allowed in law and where necessary. There are times when a young person may seek to abscond from youth justice residences. This is one of the reasons, which is one of the statutory grounds for placing a young person in secure care. But there are also times where secure care is needed to ensure the safety of maybe not just that young person that's been put in secure care, but other young people that are within a unit if that young person's behaviour is showing that it may cause harm to others. So we need to be able to have that, unfortunately, as a temporary solution to de-escalate dangerous situations.
Vanessa Walters.
Madam Chair, and thank you to the Minister for those initial responses. I suppose my initial response to that response is that 3 days is still a significant period of time, and I think my Green Party colleague has raised some of the issues in terms of understanding, trying to understand the logic for then the 3 day period, but also the very valuable question on to what extent that young person can then be made to go back into secure care and what the time period between those two instances must be, or if that's a case of judgment, and whether it would be appropriate for there to be some statutory provisions around the gap between those potential periods. The other issue is that secure care is also tied to very broad discretion in terms of when that can occur, and just looking at the scope of searches that can be done under these provisions as well, it is quite considerable. So under new section 17(2)(a), search can be any article. Under 17(2)(b)(1), it could be anything that could, while in the possession of a youth justice resident, be harmful to the youth justice resident or any other person. So I think the point we're trying to make is that the discretion here is extremely broad, and the question is whether there's consideration of how that could be drawn down. When I was working at Youth Law, Aotearoa visited Whakataka Pokai, and with educators we used to go in to deliver sessions, and there were times on multiple occasions when simple objects would go missing, and that would restrict the provision of those legal services to those young people. I remember at one stage it was a pen that had gone missing and not been identified. So while I completely understand the Minister's explanation of it not being an isolated sort of cell that this young person is in, there are certainly large restrictions that are made around young people in care and a huge amount of discretion. So just one general point. I've also just been looking at the Minister's amendment paper, which amends clause 17, and under the explanatory note it amends the current definition of pat-down search in section 384A to ensure that it covers not only the youth justice resident but those who enter a youth justice residence. I've just spoken to one of the roles I used to play entering a youth justice residence, and so I have just an observation that I think it would have been useful to consult with some of those entities that are regularly entering youth justice facilities to hear their views on the pat-down searches. My second question, because I haven't had time to go back to the Principal Act and check the cross-reference, but would it only be pat-down searches, or are there other provisions within the changes made in this bill that would also apply to visitors or professionals coming through to youth justice facilities? I do also want to speak to some of the amendments that the Honourable Willow Jean Prime has proposed, and a first question here would be, what advice did the Minister seek regarding how the use of force is consistent with the Royal Commission's findings and recommendations that found that laws and regulations surrounding the use of force were often ignored when they were in place, and in reality legitimised the use of force, leading to severe harm, abuse and trauma in far too many cases. Now, the Honourable Willow Jean Prime has proposed an amendment in terms of to clause 17 for section 38(4)(a) in the definition of authorised person, after paragraph B, inserting a person who has received training in de-escalation methods appropriate for children and young people. She's also proposed a similar but different amendment to clause 24 section 38(4)(h), where she proposes amending after the heading, inserting a new subclause 1A, that no member or staff may use physical force in carrying out a search authorised by section 384C unless that person has first used de-escalation. Madam Chair.
Vanessa Walters.
Thank you, Madam Chair. Unless that person has first used de-escalation methods appropriate for children and young people, which the person has been trained to use. So the question here is really whether the Minister agrees that it would be preferable to avoid the use of force, and whether, if she agrees with that, she would agree to those amendments, which would then give statutory, which is great and that's wonderful, but whether she would then agree to statutory direction in terms of that being the preferred method. Again, just recognising that there's a huge amount of discretion in this area, and having been into many of these facilities, one, I was struck by the good faith of the staff who are in those facilities and who run them. However, it is a broad amount of discretion, and these are young people who don't often have access to easy avenues of complaint or raising issues. So it's a space where clear statutory direction could be quite valuable, and again, I think there are several amendments here from the Honourable Willow Jean Pride that the Minister could consider. I guess the question is what advice the Minister has had on whether provisions like this would be useful in terms of directing that those staff are trained in this area, that de-escalation is the preferred method before search as well. Thank you.
Madam Chair. Oh, sorry. Sorry, I had called Senator Paul. Sorry, Minister.
Use of force, if you wanted me to do my questions? I don't know how this works.
You've got the call. You can take it or not.
Thank you. Yeah, so I have some follow-on questions around the use of force, so maybe this will mean that the Minister could address both of our questions around the use of force and a consideration of our amendments that seek to put some more safeguards in place where force is used. And just to kind of comment on the answer that the Minister gave me before, I think it should be appreciated that not everybody can go into youth justice residences and into these state care institutions. I don't think we should be able to do that in the same way that we are able to visit any prison in New Zealand. But just, you know, the Minister was talking about the true nature of what secure care looks like. And, you know, kind of saying that the way that I was describing it may not reflect the reality, and that might be the case, but we don't know because we're not able to go into those. We weren't able to see the secure care residents when we were at Te Punawai, actually, and I've tried to visit Korowai Manaki as well, but have been denied 3 times. So, like, we don't have the same access that the Minister has, so we are going to be asking questions because apart from herself and apart from the Independent Children's Commissioner, we don't know what the reality, we know the laws that surround youth justice residences and state care, but we don't know what the reality of that looks like, hence why we're asking questions to try and determine what that looks like so that we can put the right safeguards in place to protect children. So my questions are around the use of force, and I'm going to be talking specifically to our amendment paper number 366. And this is an amendment that looks to remove all provisions for the use of force against youth justice residences. Now, obviously during this submission process, there were people who came and spoke about the use of force. What is the, when might it be necessary? What is it used for? And what are the safeguards that can be put in place? It also made me think about the Oranga Tamariki responding to a serious youth offending bill that came up, and we had lots of organisations during that time come and talk to us about the use of force that is permitted for third-party providers in the setup of the boot camps for young people who are absconding, and there were lots of questions and valid points raised about what is the use of force, and there are many people who believe there is no justification for the use of force against children, which is a viewpoint that we tend to agree with. But I guess what the balance that we're trying to strike with this amendment is how can we make sure that a youth justice residence worker or anybody who's working with these tamariki truly resort to the use of force as a last case tool. We want to know what processes will be in place to make sure that every option is exhausted before a staff member resorts to using force against that young person. What are some of the modern de-escalation techniques that a worker might be able to employ before they resort to a use of force? but more importantly, what kind of training are these workers who are going to get, I mean, that's a lot of power, allowing someone to be able to use force when carrying out a search or preventing a young person from absconding. That's a lot of power. So what training will go into these workers' programs and regimes in life to make sure that they know that the use of force is a last resort, and so that they are really confident with non-violent de-escalation techniques that they can employ confidently before they resort to force. So what is the training going to look like for those workers? And then more importantly, what is the evaluation process that follows after that use of force event? Will it be monitored? Will it be tracked? Will it be recorded somewhere? Is there a chance for all different people involved in that residence to come together and actually evaluate that use of force? So in prisons, when there is a use of force, the best practice is that there'll be a bit of a multidisciplinary team that come together. They look at the body camera footage, they look at the CCTV footage, and they ask themselves, did we have to use force? Did we have to escalate this? Or could we have tried something else differently? And they bring in mental health professionals, kind of psychological experts, the officers themselves, and they kind of look at the situation to reassess. And that means that there is better practice because people are more aware of the different tools that they can utilise before resorting to force, because it truly should be a last, it should be the last thing that anybody thinks about. So appropriate, Madam Chair? So appropriate training, and then the after in terms of evaluation, what's happening there. And we're really interested to know how might they keep a record of what de-escalation practices were tried out before they resorted to the use of force. The other question we had was in terms of recording those incidences where force is used. So like I mentioned before, with corrections officers, they have got body cameras and there is CCTV everywhere. I acknowledge that there are bigger sensitivity and privacy concerns when it comes to children who are in these residences, but how are they going to be able to reflect on their use of force? Like, how will that be captured so that they can reflect? Because otherwise it's kind of a he said, she said. The young person says they who knows, held me down or put their knee on them, and then the officer says, or the social worker or youth worker says, no, I didn't do that. So how do we keep a record, a physical record of what actually happened, and how is that recorded? And I guess the other point I'll make in terms of the use of force is when weighing up whether to allow for the use of force and whether to expand that provision to other people as well, how did you strike a balance between professionalisation, which you talked about in your opening speech, Minister, versus institutionalisation? Because one of the core recommendations from the Abuse and State Care report, Whanaketia, was the institutionalisation of those residences or programs, and how that could lead to a lifetime of staying in institutions, whether those be in mental hospitals or in prison. So how do you strike that balance of professionalising things so that there are appropriate safeguards, so that people do have appropriate training and expertise and evaluation processes, but how do you make sure that that's not just institutionalising an entire generation of young people where it becomes normalised to them to have force used against them by people in authoritative positions in their lives?
Madam Chair.
The Honourable Karen Shaw.
So, Madam Chair, there are quite a few questions there. So one was around Section 384A of the Act defining pat-down searches. So I just want to clarify that that amendment just amends the definition to ensure it covers non-residents, to make sure it's consistent with 384KC. It replaces references to child or young person with the term person. It's just to tidy that up so that they are consistent. When it comes to pat-down searches, those will only happen if there's a circumstance where they don't want to go through the scanner, and it's a bit like an airport. If something pops up just a quick pat-down search, just like you would at the airport, or if you don't want to go through the scanner, it will be given as an alternative. So it's not a punishment, it's sort of used as an alternative option if needed. So that's just really a tidy up in the legislation rather than a change. So I would like to go through some of these amendments that have been put on the table, some by Kaharangi Carter from the Green Party. So I'll speak to Amendment Paper 370. This amendment requires reasonable modern de-escalation practices to be exhausted before any force is used in carrying out a search, and there's a bit more to it, but what I would say is I do not support this as legislating modern de-escalation practices in the context of searches would make the safeguards for searches different from safeguards for other contexts where force may be used, for example in self-defence or in defence of another person. Nothing in this bill allows for force to be used as a first resort in the context of search on entry. And so the next amendment paper number 369, Kaharangi Carter. This amendment is to reduce the ability to retain images generated from the use of technology. I would say that this bill is clear that the scanner search images must be disposed of within 24 hours, meaning that they can be disposed of sooner if necessary. In those cases where a harmful item is identified by the scanner, it could be useful to retain the image for a short period of time to allow staff and managers to make necessary decisions about the search. For example, if an image indicates a young person has swallowed a harmful item, decisions will need to be made about whether seeking medical attention or whether the image should be copied, photographed or provided to medical professionals. The Privacy Commissioner in his submission on this bill found the restriction on the retention of images was generally appropriate. So we won't be supporting that amendment. The amendments 368, amendings section 16, section 370. This amendment prevents children and young people from being kept in secure care for longer than 3 hours. The existing time limit applies to the period before approval must be sought from the court for an extension. Reducing the period to 3 hours is not a practical time frame in which a court decision can be sought. If the intent is to cap secure care to a maximum of 3 hours without any possibility of court approving an extension, then further amendments would be needed, so we wouldn't be supporting that amendment. Amendment number 366, around removing provisions authorising the use of force against youth justice residences, including existing authority in the Act to use force for searches generally, not just for those proposed new authority to use force for searches on entry. I would say without this provision to use of force in the context of a search on entry, Oranga Tamariki would have no authority to touch the child or young person who is not cooperating. For example, even to just guide them to a scanner. Nothing in the bill allows force to be used as a first resort, I will repeat. It is clear that an authorised person must not use force on carrying out a search on entry unless there are reasonable grounds to consider it necessary in the circumstances, so we will not be supporting that amendment. Amendment 371. This amendment specifies that contractors may not be authorised to use force against, Madam Chair.
Honourable Karen Shaw.
Youth justice residences. The intent is that ensuring that only staff can be authorised to use force. I can semi-understand the thought behind this amendment. Further work is required to consider whether it is practical to authorise contractors to carry out a search on entry, but to prevent them from using force if necessary to the purpose of the search. The proposed amendment currently, how it sits, could mean that staff would be pulled away from their duties inside the residence only to use force for the search. So there has to be further consideration if we were to look at that, but the way that this amendment is written, we cannot support that. And now we have amendments from Willow Jean Prime. I've got the amendment number 1, I think we've got it as amending section clause 17, section 384A, amended definition of an authorised person. We won't be supporting this as the bill already allows for regulations to prescribe the qualifications for being an authorised person. Amendment paper from Willow Jean Prime number 2, amend 24 section 384H, amended use of force in carrying out a search. It's pretty much the same answer I gave to a previous amendment paper. Nothing in this bill allows for force to be used as a first resort in the context of search on entry, so we will not be supporting that amendment paper. Now this has been brought up a little bit around recording inspections and searches. This is something that is allowed for within regulations and staff training and making sure that we are recording incidences, and this is in the bill section 447 amend regulations. There is number 7, prescribing procedures by which a person may make a complaint in relation to search and how that complaint is dealt with. And then 8, prescribing record-keeping requirements relating to searches conducted on entry to a youth justice residence. So that has been taken into consideration around how we do record-keeping and how we make sure that there is accountability in that space. So we won't be supporting that amendment. Willow Jean Prime Amendment number 4, clause section being amended 28, new section 384KB. This amendment is around use of force in carrying out search in youth justice residences. Same answer that I've given in the past. Nothing in this bill allows for force to be used as a first resort in the context of search on entry. And Willow Jean Prime number 5, new section 384KK. This has been covered in another amendment around record keeping, so we will not be supporting that amendment. So I think there's only a couple more amendments that are in here that haven't been spoken to. If I've missed any, please let me know. But hopefully that gives an explanation as to why we won't be making those changes.
Can I just say, before I take the next call, for members to please highlight which clause that you are speaking to. It just helps with the order that we're trying to work through in the paperwork. Thank you, Helen White.
I want to start before I get onto section 617 saying I am really curious as to the Minister's answer to the issue about repeated detention under the 72 hours. I thought that was an excellent point by people, and I'd really be very interested in hearing what the response is in terms of the misuse of that by repeatedly detaining with a few hours in between perhaps. And what safeguards are in place with regard to that. I do know that's an issue in many clauses about detention, that people game that system if they can. So I would be very keen to hear about that. But I want to ask about section 17, which is the harmful item section. I can see in the section 2A that there is that a harmful item includes one that is has reasonable cause to believe is likely to cause harm, but that seems to me to be an undercooked section in terms of setting out the principle of harm, because if I go down to the list of, under B, of things that have already been identified as likely to cause harm, we get to an example here of an electronic communication device, which I can see there may be instances where that is, and there's a further section on that further on I'll come to, but I can see that it could be or it could be not. It is something that most of us have all the time, and there will be arguments as to why it is actually not harmful for people to have those things. I'm also interested in, I'm not a fan of tobacco or vaping. I do think there is a harm, but there's a proportionate nature to those things. We have lots of adults who self-medicate with tobacco and vaping, and they're not seen as particularly harmful with regard to their mental health. They are a method of self-medication and comfort. So these things are clearly on the list as harmful, and I wondered what balance had gone into making sure that there is an availability of things that might be things we would expect we would respect autonomous individuals to be able to make choices about. We allow adults to make those choices. But in this situation, we're kind of clamping down really hard. So you've got a child who's coming in and they're just stripped of all these things that have been used to probably have been used for comfort, etc., and they're in an extremely challenging situation. So is there any discretion in that situation? I completely agree that I would not want my kids vaping or using tobacco. I'm not suggesting that it's it's not got some harm associated with it. I'm just asking about in this situation, why has this been prohibited in this way rather than some sort of proportional assessment at the time, or is that built in? Is it something where there can be a discretion involved? Because I can't see any form of discretion here. And then I want to ask about section 17 2B 11 in the Roman numerals, which is an article or thing declared to be harmful item by regulations. And I wanted to ask the Minister to explain the process around how that decision would be made, given what I've suggested, which is that we've got a fairly spare, a minimal principle of harm in the first clause. Is the process simply applying that standard of that the people making the decision to put something new on the regulations are simply making a case that they have reasonable cause to believe it is likely, and again the same kinds of issues involve proportionality and that kind of invasion.
Madam Chair.
Madam Chair. Thank you. I'll listen.
The Honourable Karen Shaw.
Just in regards to the questions that have just been asked around harmful items, the harmful items is the same as the list in the Corrections Act for starters, and so that's how we came, part of how we came to the decisions to be making that. But what I want to make really clear is there's two areas as well to this. So you were speaking around vapes being something that can be, some items can be an item that can relax a young person, that they're used to having it, and that it may not be harmful. But what I would say is that staff and people who work in this area have seen these items be used in very harmful ways. They can be used as shanks that can cause major damage and even death with just that item alone. And it's not just really up to discretion. There has to be a link between an item and harm. If the item is not likely to cause if the item is not likely to cause harm to a child or young person, and there is no reason to add it to the list in regulations. There are also existing processes in place to curb the power of adding inappropriate items to this list. For example, the role of the Regulations Review Committee is to scrutinise the regulations to ensure they are made fairly and used consistently. The bill was also amended at Select Committee stage to include guiding criteria for this legislation making power. This will require the Minister for Children to consult with the Minister of Justice and be satisfied on reasonable grounds that the harm that could be caused by the items justifies it being added to the list, or even removed from the list if requested. So that puts in that safeguard in the areas of harmful items. We want, this is not about taking away what young people enjoy. They are in an area where they are high risk, where they, in a youth justice facility in particular, they are court ordered to be there. There are some restrictions that come with being in a court-ordered youth justice residence where some of your freedoms are taken away, and there is good reason for that. But what I would say is that we do not want to see a staff member in danger of being stabbed. We don't want to see a young person in danger of being stabbed. And part of the responding to the abuse and care legislation, it was very clear throughout that we needed to listen to the voices of young people. And young people within youth justice residences have consistently said, this is my home and I want to feel safe. And so if you know you are going to be in a unit with young people that have weapons on them, that have the potential to stab you or kill you, you are not feeling safe. And so what I would say is this is a valid response to making sure that young people in our care are safe.
Mariamino Kapakingi.
Chair. Morena, Madam Chair. Morena, Minister. I'm still in the 16, and probably might move into the 17, section 17. But and I guess to start by saying this, if only the descriptions of dark and dank and those types of descriptions were actually an exaggeration. The Whanaketia report shows very clearly that they were not exaggerations; they were the horror that people lived through. So, and I think it's important not to bring those things back into memory for drama, but more for centering ourselves in the conversation. So I just want to remark in that way. We get as a party and acknowledge that the efforts going forward to improve what we failed, and you will recall, Minister, in the House when I spoke to the fact that there was an apology, there were apologies provided, but by no means does that mean that all the survivors have to forgive us, and I think we have to do better. So I want to take us to the question about training. I think there's something really important in that. I've heard words from my colleagues on the right, like de-escalation as a smart and good idea, but that takes real, solid, enduring training and monitoring and assessment as to whether people are up for that. So I'm keen to know if you can, what is the model of care? Because if we're talking about moments, securing, putting young people into security for whatever reasons, it's the moments before and after the secure. So 3 days in secure is one thing, but the 22 previous days is really where I'd want to understand in a more thorough way, Minister, as to what does that actually look like? What is the model of care? Can that be described? Are you confident and assured that it is rigorous enough, that it is deeply understood from the young people and their families as to what it takes to provide a model of care, particularly for mokopuna Māori, not for only mokopuna Māori, obviously. I'm not that silly. But I don't hear that in the descriptions from what I'm hearing this morning. I can hear intention, but I don't hear deep conviction in that way, and I'd like to understand that better. The use of force, even when we use that word description, force, it conjures up all kinds of horror. And I have this ngā rākau rikiriki, which is the poetry, which is the document that was provided, put together by survivors. It's worth a read and a reminder. So Minister, I genuinely want to feel whether any of the discussions or the questions this morning are appreciated in your responses, so it gives us confidence that we can do this better together. Thank you.
Madam Chair.
The Honourable Karen Chura.
So, Madam Chair, I just want to go back to a question asked by Member Timothy Paul. What training was there to ensure that youth workers know that use of force is a last resort? And what is the evaluation process after a use of force event? So I thought that needed to be answered, so I want to make sure I give you a good answer on that. Standard operating procedures is that physical intervention can only be used when verbal de-escalation techniques have failed. And I do agree that in the past that hasn't really been followed very well, because there wasn't a very good training program in place when people came to work within youth justice. This has been a real passion of mine, making sure that we're not setting staff up to fail when they go to work within these facilities, but B, making sure that they have an understanding of what their obligations are to keep young people safe, and that we need to treat these young people with dignity and respect. Yes, they are in there for reasons, but they're also human beings that deserve to be treated with respect. I'm very passionate about that, and I want to make sure that we give the tools to these staff to be able to do their job and do their job well. So that was part of the professionalisation of the workforce program that we've been working on, making sure that every staff member that goes to work within a youth justice facility is well trained. So part of that training is around that, and also retraining staff that have been working for us for a while that may need a reminder in that space of what their obligations are. So now staff are trained in verbal de-escalation with restorative practice in addition to proactive prevention of events like fights. And after the use of force, it will be reviewed by a team leader. It will also have a process to escalate internally to Oranga Tamanaki escalation team, where any concerns about the appropriateness of the use of force can be investigated. And I think that's actually really, really important, because you are right, it is a massive power to have, and we have to make sure that there's really good oversight on that. And the use of force, any use of force, whether it be showing a young person to the scanner, if we have to physically move them in any way or touch them in any way, must be recorded in a daily log and also reviewed for appropriateness.
Todd Stevenson.
I move that debate on this question now close.
I don't think we're quite there yet, but I do have to note to members that there is a lot of repetition coming back in around the timing, the secure care and the use of force. So look, there's quite a few clauses in this particular part that are still to be explored, so I do encourage you to move on. Vanushi Walters.
Thank you, Madam Chair. My questions are on a few other parts of the bill. Can I first just thank the Minister for her extremely thorough responses and addressing the amendment papers individually. That was very helpful and actually addressed a number of questions I would have otherwise asked, so thank you for preempting that. I'm looking at, so where are we? Clause 23. Which is the amended section 384G, restrictions on searches. So this clause replaces the wording must be carried out by a member of staff who is of the same sex as the child or young person being searched with must not be carried out in view of another child or young person in the residence. So quite different meanings or quite different objectives in my view. And my question is, because I've also noted that obviously we have the new section 384AC, which is around the plan, and really appreciate the language in that around the needs of the child and what's reasonable, and that potentially the child could express a view there about who should be searching them. But I'm also very aware of the lack of explicit language, given that if we look further at new section 384KF, there's a new section 3A that says a person other than a youth justice resident may request that a pat-down search be carried out only by an authorised person of the sex or gender identity chosen by the person. So it's very explicitly giving this right to others who aren't youth justice residents, and I must also commend the Minister on the inclusion of gender identity chosen by the person within that section. My question is really why that explicit wording wasn't included in 384AC, and the intent of the removal of some of that language in new 384G as well. My other question is in relation to back to 384KF, new subsection 3, which lists the people who must be present when a youth justice resident is being searched, and it includes B, which says that a prescribed person can be someone who's named in regulations made under section 447. Again, I haven't done the cross-reference, but I'm wondering why we don't have a closed list in legislation, and who that provision might then include. Just feels to me like the appropriate people. Like 3A2 is worded so broadly, another authorised person. I can't imagine who might be included under regulation who sits outside being an authorised person. So just those two issues for me. Thank you.
Madam Chair. The Honourable Karen Shaw.
I want to come back to questions from Helen White and Timothy Paul around the period of time in secure care and repeated use of secure care, because that's been raised a couple of times. So I just want to address the concerns where you were asking if when a young person comes out, what's to stop the abuse of reusing it. What I would also like to say is I just want to bring a little bit of balance to this, because we have some pretty amazing staff that take care of our young people, and whilst at times there are people that do skirt those lines of being responsible caregivers for our young people, most of our workers go to work every day to make our young people's lives better. So I just want to make sure that people have an understanding that nobody goes to work to try and torture or break the rules and have a young person repeatedly in secure care, just to bring a bit of balance to it. This bill's not changing the existing time limits for secure care, although a young person can be placed in secure care again. With each placement, there's a strict criteria for admission, so they have to meet that criteria, and additional safeguards for preventing continuous care. So it can't be for the same offence that they were put in there the first time round. They have to really justify why that young person is being replaced there. It may be a new event that has happened. So there's a very strict criteria for admission.
Timothy Paul.
Thank you, Madam Chair, and thank you, Minister, for your detailed answers to our particular points. Yeah, as I said at the beginning of the session this morning, we're supporting the bill, so it's good to use the session to just clarify and make sure we've got some of those safeguards right. So your answers really assist us in feeling a little bit of confidence in what we're all, or mostly all, agreeing to. So I wanted to start with the a few questions ago, there were some questions from Helen White about harmful items, and I just wanted to touch on that a little bit because totally agree with the Minister. I have also heard from Tamariki that these, prohibiting these items makes them feel safer, and totally support that. Whatever makes them feel safe in their residence or the place that they're calling home for that period is 100% justified. I guess and it's also justified in light of news stories last year, I think, around the Korowaimanaki, where contraband was being brought in. Vapes was one of the items mentioned, so I'm glad that this kind of responds to that, and I hope the Minister is keeping those managers accountable for those findings, I think, from the Children's Commissioner. On the harmful items point, I guess what I'm keen to understand is with more harmful items comes a greater level of searching when families come in to visit their tamariki or their whānau who are in there, or not just family, maybe friends, mentors, whatever. One thing I have heard from rangatahi who have been in youth justice residences is that the family visits can make a big difference to their the care they're being provided, or the maybe the counselling they're getting in there, or the programs they're doing. Those family visits really reinforce the positive things that they're learning. And knowing the kind of backgrounds that a lot of these kids come from, some of those families might have experience I guess, having been, not saying all of them, but some of them may have been in prison or, maybe a bit sensitive to that institutional nature. So I wanted to ask a question to the Minister of how do you strike that balance between keeping kids safe but not being too prohibitive to those families, because we want them to visit, we want them to be an active part of tamariki's healing and rehabilitation. So how did you go about striking that balance in terms of the family visits? The other points I just wanted to raise were in reference to our amendment 369, which addresses the image scanning, which we haven't touched on yet, and also 371. But I'll start with the image scanning because we haven't really touched on that yet this morning. So obviously this bill and in clause, I'm not going to waste our time finding it, but it is definitely in part 3. The clauses and sections around the scanner searches and the images, we're really keen to understand how those images are stored. So we're kind of presuming that these images could be quite intimate images of those young people. It could be, I don't know, normal images as well, but there could be some really sensitive images. So we're keen to understand how those images will be stored prior to them being deleted. We know that this act will mean that they're deleted a lot faster, but how will they be stored? Is it a secure storage software or whatever it ends up being? How will we know and monitor that those images have been deleted within that 24-hour window? Who has access to those images? Does that include third-party contractors? Is it just the people that work in the youth justice residence? Is it the police? Is it other youth justice residences around the country? So keen to understand how those are stored, who has access to those images, and has there been any communication with the Privacy Commissioner or people in those kinds of roles who specialise in privacy and storing sensitive information and data? Because some of us might recall a couple years ago, I believe, there was this kind of big drama about police taking lots of images of young Māori on the street and not storing those images securely. And the Privacy Commissioner found that there were tens of thousands of unauthorised, unsecure or insecure photos of young Māori children just floating around and being stored on these devices. So I guess the privacy of those children is of the utmost importance to us, and also keen to understand how does that deleting happen? Where do those images go once they've been deleted? So keen to understand the dynamics of the image scanning aspect of this bill.
Madam Chair.
Honourable Karen, sure.
Sorry, I'm still a little bit behind, so I will answer that question soon. But I just want to go back to the harmful items and also address what Timothy Paul has just also said around staff as well. We have to be careful that we're not just laying the blame on whānau members and saying this is all them bringing in contraband to these young people. There's multiple layers of indirect harm with some of these items. So I'll give an example around vapes. They can be made to use as shanks, as we've talked about, but they can also be used as a contraband trade or commodity within a youth justice residence, and that's not just by young people. There is the temptation for staff to use them in ways to get young people to do things. So we want to make sure that we're holding staff to account when we're doing searches of coming into residences. This doesn't... Aside from legislation change today, there's a lot of practice change going on in that space too. So if you look at that search on entry, which we're looking at, when you go through, say, a corrections facility, there are some practices there that staff have had to do for a while, and one of those is the clear plastic bags, so that we can see what staff are bringing into residences and holding them to the same level of accountability as any other visitor that comes into residence. We want to stop this contraband being used as a commodity, which can often lead to fights and lead to cliques that become quite dangerous within a youth justice residence. Around the image technology, I think it sounds really scary that we're bringing in this image technology, we're scanning people, but what I would like to say is it's not as uncommon as we think. You walk through an airport, you get scanned at an airport if you want to catch a flight. You often can come to these restrictions when going to court. There's multiple places where you walk through a scanner and nothing to see here, not a problem. But what I would say is, yes, we are aware of the unintended consequences of whānau not wanting to visit. That it could be quite a traumatic experience for some whānau if they have been incarcerated in the past. So we want to make this process as friendly as possible, but also, quite frankly, we need to put the safety of the young people in our care at the very front of our decision making. So we're very clear that there will be training in this space around how we deal with whānau visitation. We will make sure that it is made very clear before they come into the residence what is expected of them. Currently, there is a sign on the entrance saying, please do not bring these items in. That has not worked, obviously. And so with the scanners, that's also why we changed the entry, because it had the possibility of actually searching people who were just coming to the reception to ask questions. So by changing that entry, we have an area where we can first speak to the visitors, set that expectation before going through the process, so that it's not just wham, I'm stuck in this process where I can't even speak to somebody and I'm already being searched. So we'll set the expectations very clearly in the beginning. If something is found through either the scanning process or the pat-down process, if it is not an illegal item, then they will be given the option to kind of take that back to their vehicle and then come back again. So we want to make it as least restrictive as possible, but making sure that we're keeping our young people safe. Helen White.
Thank you. First of all, I just wanted to thank the Minister for the thorough answers on the issue that I've raised about repeated detention and on the harmful objects. My only remaining concern in that area is my concern about self-soothing and addiction to things like nicotine. And I'd seek the Minister's assurance that people would be given appropriate interventions in terms of things like nicotine patches, etc., because they're undergoing huge amounts of stress and they're being asked to basically detox at the same time quite often. So I would like an assurance that there are processes in place with regard to alcohol and nicotine in that regard. But I actually want to move on to the area of vehicles and dogs because they're both important issues. With regard to vehicles, I guess that what most New Zealanders would wonder is if we've got this very comprehensive system of search and things aren't coming in, why is it necessary for us to search vehicles? The problem, I did a lot of work on these kinds of searches when I was a lawyer, and in relation to workplaces where cars were parked in the car park. And these were always the balancing acts that needed to be done, like giving people the kind of appropriate warning that their vehicle could be searched, but also what use it was in those situations, whether the invasion of privacy over a car was necessary. When it comes to cars, one of the issues is that you're not in control of them all the time. So people would find things in the cars that were perhaps illegal. I remember I had a case where it was equipment for the use of marijuana, and it was equipment for the use of pee. But in fact, it's very hard to link that to the person who's driving the car because so many people are in the car. So I would like to know what's the logic here and what procedures are we copying and following with regard to why are we looking at the vehicles as a search in that way. And then the other issue I'd really like to know about is the use of dogs. Now I can see this has been considered in this piece of legislation in terms of the worry with dogs is that they're actually very frightening, and I can see the legislation has said that they will be kept at a distance from the people, etc. I would like for people who are listening today to hear a little bit from the Minister about what kind of dogs are involved, whether there have been any instances where those dogs have got out of control, because it's very hard to control a dog. Actually, it's one of the it's one of the challenges that many of us face who've had dogs, is they're not actually entirely in our control. So, given the fact that these are trained dogs, I'd like the Minister to talk about why we use the dogs, what they can do that is not able to be done by human beings, and what safeguards are put in place in really ordinary language, like what kind of dogs we're talking about here, and whether there is any risk that the dogs would be aggressive or would frighten people involved in this process, given that we're often dealing with really traumatised people. So thank you. I'd be grateful for your answers to both those questions.
The Honourable Karen Shaw.
Thank you. So this is just I'm just responding to Venushi Walter's question around Clause 23, Section 384G. Section 384G relates to searches inside residences. So the bill removes the current requirement that pat-down searches only be carried out by a person of the same sex as the child or young person. And this is done because it would completely contradict the new section that it's being replaced by, which would require search plans under Section 384AA, where a child or a young person can express the gender or sex of the staff member they would prefer to be searched by. So it's just to clarify that, otherwise we'll have two contradicting pieces of legislation that don't match. So it's just to tidy that up to make sure that we aren't contradicting what we have said we will do, and it's making sure that young people feel safe in their home and feel safe in the processes that happen within their home, because this is their home, and whilst there are quite a few more rules within their home, we want them to feel comfortable with the processes, to understand the processes, so that it's less traumatic than it's needed to be and less traumatic than it has been in the past. And also to set the expectation upon staff members of what is expected of them in respecting a young person's wishes around how they are searched and who they are searched by.
Tamitha Paul.
Thanks, Mr. Chair.
Tamitha Paul.
Yeah, thank you. Thanks, Minister, as well, for those answers. My questions follow on around the search provisions in section 28. The one I'm keen to ask a few questions about is around the vehicle searches. So this bill allows for people, for vehicles that enter the perimeter of a youth justice residence to be searched. And we've this morning been having a bit of a conversation about striking that balance between safety for Ngā Tamariki, but also making sure that families feel safe and comfortable to visit, recognising that they're a really important part of the healing rehabilitation journey for young people. So I was interested to know, obviously this bill puts in lots of measures in place within the kind of administrative office, or when you enter a justice residence, where there's a lot of screening, as Helen White was just talking about. There may be dogs, there are the body image scanners, there are the various layers of security that are now and presently in place. This bill talks about those vehicles, and I guess I'm just a little bit worried about those powers around searching a vehicle because of the possibility that it might deter people from coming in. And like, let's be real, like sometimes in our cars, I don't have a car, but if I did, like I might have friends in that car, they might like, a vape might fall out of their pocket and there might be a vape on the ground or something like that, and then I guess I'm a bit nervous that a family might get searched and, oh, you've got an unauthorised item in your vehicle, and then they're not able to visit their kids or their niece or nephew or whatever it is. So just keen to understand why the extra precaution into the vehicles. Is that based on an event that's happened, or is it that we're not feeling completely confident in the protections that are in place at that office? I was going to call it a receiving office, but that's not what it is. So that's that question around the searching vehicles. I just also wanted to raise our Amendment 371, Amendment Paper 371, which talks about within Part 3 there are amendments that specify that an authorised person is able to use force, and we wanted to just question this a little bit and make sure we understand what the implications of this amendment are, because we're wondering if this means that contractors who are maybe running a program or something within a youth justice residence, does this mean that they too are able to use force? So we're quite keen to just interrogate this a little bit more, because our preference, in light of the answers the Minister's given us around training, de-escalation training and the evaluation post-use of force, we're keen to understand if those measures would be extended to any other people that might be granted greater force powers within this bill, particularly those who might be third-party contractors, acknowledging that in that pool of third-party contractors could also be like iwi social services and things like that. So keen to understand the vehicle search, the rationale behind the searching of the vehicles, and the weighting of how this might deter some families from visiting their family or friends or mentees or whatever, just out of that fear that they might have some harmful items in their cars, which, you know, as Helen noted, some of those are legal objects that adults use for various different reasons. So has that been considered? And also on the use of force for third parties or contractors, what steps will be in place to make sure, again, that it's a last case resort, and what kind of training and evaluation might be provided to those people using that power?
Mr. Chair. Thank you. So in regards to section 384kg, search of vehicles entering youth justice residences, I just want to make it very clear that it's vehicles that are brought within the secure perimeter of a youth justice residence. The vehicle may be searched by an authorised person for the purposes of detecting any unauthorised item. So it's the secure perimeter, so it wouldn't be the car park that a visitor comes in to visit. It's where contractors may come in through a back gate into the secure area. They might be bringing items in for kitchen, they might be bringing anything in, and it just gives us the ability to be able to make sure that contractors aren't bringing in unauthorised items, because they will be skipping the process of going through the scanner in the initial entrance to residence. So it is all about the secure perimeter of a youth justice residence. So just to clarify, we won't be putting dogs in searches on a family that are coming to visit and park in the car park. The use of dogs will be extremely limited, and will it would have to be quite significant of an issue to use dogs. Maybe if we found somebody coming into the secure area in a vehicle with cannabis, but quite a fair bit of cannabis, we might call in to get that checked by dogs. It's only to be used in shared spaces, and the dogs will be controlled by police or correction handlers, not youth justice staff.
Thank you, Mr. Chair, and thank you to the Minister for her response in relation to the new section 384AC. I think it's reassuring to know that that would be part of the plan. My concern on that one was more about whether we ought to make it explicit, given that in other sections we make it explicit that non-residents of the facilities can elect either someone of the same sex or the same gender. So I was just trying to work out why the language was different in that section versus 384AC, but I am reassured that that remains a choice for the young people. My next question is in relation to new section 384KD. So we had an earlier conversation about people being able to elect whether they went through a scanner or had a pat-down search, and one of those being sufficient. My read of that section is that that's correct. The question would just be that my read is also if someone were to go through a scanner and then the security were alerted for a need for a pat-down, the person could refuse a pat-down but still not fall within the section. So they've complied with one or the other, and therefore this section wouldn't prevent their entry. That's my read of the section, but if I could get some clarification from the Minister on that. The next one is consequences of refusing a search because you failed to remove an outer item of clothing. Now, this includes head coverings as well, and I just wonder whether the Minister had received advice on religious head coverings and the interaction with the Bill of Rights Act, and how that would be treated in terms of this instance. My next question is in relation to, let me find the number, new 384KC, the new, where are we? New section 7, subsection 7. To avoid doubt, the search of an authorised person under this section must be conducted by another authorised person. My question is just around whether it would be useful to include additional language about it not being the individual's subordinate, or not being from the same team, or finding other protective ways of ensuring that a diligent and objective or independent search is conducted. I have another question in relation to new section 384KF. So these are the provisions under subsection 5, which state an image produced as a result of technology must, so far as practicable, avoid showing a clear image of the body beneath clothing and obscure the genitals or make them not easily distinguishable if they are included in the image. I wondered whether it would be useful to prioritise obscuring the genitals as opposed to making it an alternative, and that way saying that the preference by far is for that to be used as an option instead of not, in making them not easily distinguishable, which feels to me quite invasive. And again, just aware of the discretion in this space and the times at which we can and should perhaps legitimately be very clear about our preferences. And I take the Minister's point that she's made earlier about, you know, the need for that discretion and the respectful way in which the people employed in these facilities conduct themselves. I do think that when it comes to searches where body parts are involved and these images are captured, it potentially warrants a more closely drafted section. So just interested in the Minister's comment on those questions.
Mr. Chair. Thank you, Mr. Chair. I just think that I just want to address the question around section 384KD, around the consequences of refusing a search under section 384KC. So what I would say is, yes, you have some alternatives. You can go through the scanner, or you can get a pat down, or it may be both. If the scanner detects something, you might be asked for a pat down. But yes, absolutely, if you do not comply with the obligations of entry, then yes, you can be denied entry to the Youth Justice residence.
Tom Rutherford.
I move that debate on this question now close.
Hello, Mike.
I want to ask the Minister about the consequences of using too much force. So there's a section here that talks about the need to be minimal.
Can you repeat the section again?
Sorry, I did have it. I'm just flicking through now for the actual section number, but it's the one that talks about minimisation of how much
you got the number?
Force is used. Sorry, I just had it and I've just lost it. Apologies. I could just go to a different question and come back to it, if you prefer. So the next question, so that is simply, I will find the section number, but the question is simply one about what happens if somebody does actually go too far in their use of force when this legislation is very clear that they must use minimal force. And I will give you the section number as soon as I find it. But the other questions that I wanted to ask were about the regulation making criteria over harmful objects. I can see that there has to be a satisfaction that there are reasonable grounds that the nature or extent of the harm that may be caused by the article or thing justifying the article or thing being declared as a harmful item for the purposes of the Act is in the criteria. And that the Minister of Justice has to be consulted about adding to that list. And I wanted, because I've talked so much about it earlier in terms of that, I wanted to ask about that regulations making power and what was envisaged in terms of timeframes on making new objects and what happens in a situation where a new object becomes is presented, which isn't in the scope so far, but would come into this regulating making power. What will happen to that object at that time? Because I can see a gap there. The world is an inventive place and new things turn up. So it's the other side of my question about making sure that we're limited and we're proportional. But there is one final issue here, which is the way that that's framed is all about the risk, but it's not about the benefit. What if you have an object that has benefit as well as risk? And I can only use one that I already know exists rather than one that is anticipated to be covered here. But you've got a situation where you've got a communication device some of the features of that are actually probably very good for people, and I can see that the legislation has included references to telephones that are clearly limited in their ability, and I presume that's because they're permitted because there is a benefit to people being able to continue having that kind of communication available. So what happens in this wording, it looks to me as it's balanced towards risk rather than benefit, and in most areas of the law we've moved to balancing those two things in our words as well, saying we need to actually look at the benefit as well as the risk when we decide whether to prohibit such an object. So I would love to know about that. Apologies for not coming to you with the section number with regard to the other thing. I will actually just sit down and find it. Thank you.
Mr. Chair, whilst I understand your questions around a harmful object, I actually think I've been very thorough in my explanations around harmful objects a couple of times now, and have gone through the process of it must go through a process to be added to the list or taken off the list. So I'll just leave that one because I think I've explained that one a couple of times. But what I would go into is what would happen to a staff member if it is shown that the use of force was unnecessary or inappropriate. So after a use of force, it's reviewed by a team leader, which will and also be able to be escalated internally to Oranga Tamariki around any concerns of appropriateness of use of force. If it is found that that use of force is questionable, I would assume and expect that that would be a disciplinary, and that would actually be a matter when it comes to their contract.
Helen White.
When I was talking was it's section 384KB, which is the use of force in carrying out. I think that you've answered my question in terms of disciplinary process. I also wanted to just reflect on what the Minister and I had talked about earlier in terms of repeated searches. While I agree that there would be a disciplinary issue involved, there is also probably a role here for the Ombudsman in both situations, where they would be looking at patterns of behaviour. And if things like this were occurring and there was more force being used than necessary, I would like the confirmation of the Minister that one of the checks and balances in place is our Ombudsman, who would be able to have access to this information. And I would still like the answer to the question about what happens with an object that hasn't been identified as harmful but may have those results, and the issue about I don't believe that the Minister has ever answered the question about that proportionality of some benefit in a new situation. So I am not talking about the same section. I am talking about a later section in this Act which we have not discussed before, and it has a different nuance, which is those new objects that have yet to be classified. Thank you.
Mr. Chair. When it comes to the oversight of a youth justice facility, the Ombudsman does have access to that information. Mana Mokopuna does regular reviews of our youth justice facilities. We also have a panel who is there to take on concerns of young people and make sure that those concerns are addressed. There are plenty of oversights available in that space.
Just before I take the next call, if members could talk specifically about the clauses that they're talking about, that would assist the House. We are tracking which clauses have been discussed and which points have been addressed, and now I'll go to Glenn Bennett.
Thank you, Mr. Chair. I just want to seek clarity from the Minister, who did comment on Clause 17.4, Section 384A. It was around the amendment from the Honourable Willow Jean Prime, and it was around the authorised person and the request in our amendment paper around adding a person who has received training in de-escalation methods appropriate for children and young people. The Minister, when she responded, just said, it's described in the Act and who an authorised person is. The reason I just want to clarify that, can you point me to where that is because obviously the protection of our young people is of supreme importance. The reason we are in the House today debating this is because of abuse in state care, but it's also about protecting the state to make sure that we have the right people with the right skills. So I just need clarification that there is a description of what an authorised person is to make sure they have the skills, because we know we're dealing with with young people who have trauma, young people who are elevated or escalate situations, and we need to make sure that we protect the people working for them, working for the state, working in these institutions, as well as obviously the most important is the protection of the young person.
Mr. Chair.
Stuart Smith.
Question close.
Vanessa Walters.
Thank you, Mr. Chair. I am looking at new section 384KN. So this is the power to seize articles found on a search, but in particular its connection to new section 384KC, which is not residents but people, visitors, authorised persons who may be coming on to the property. And my question is really about what is appropriately placed in primary legislation versus secondary legislation, because those sections taken together and the broadness of the section as it's currently drafted mean that regulations would set out how long an item that was seized from a visitor to a facility could be potentially held for and under what circumstances they could be released. My view is I can see why you may need to withhold possessions when they're seized from residents of those facilities, but certainly for visitors, they should have that property returned to them as swiftly as possible. And in my view, given it is a search, it's more appropriate for that to be set out in primary legislation as opposed for it to be delegated. It's an issue that I raised before in terms of who the prescribed person is who who must be present during a pat-down search. And I questioned why we needed secondary powers to create other persons when we already had the wording an authorised person, and I couldn't imagine circumstances when anyone but an authorised person would be the person who was there for a pat-down search. So perhaps also just seeking a response to that. There is, as my colleague has just said, there's a question around who is an authorised person, and that's also prescribed by secondary legislation. So whether consideration was given to those definitions being held within the Primary Act. Thank you.
Mr. Chair.
Tom Rutherford.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Kahurangi Carter's amendment set out in Amendment Paper 367 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Apologies, 5 votes opposed.
The ayes are 48, the noes are 73. The question is not agreed to. The question is that Kahurangi Carter's amendment set out on Amendment Paper 368 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
12 votes in favour.
Act New Zealand,
11 votes opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
5 votes in favour.
The ayes are 51, the noes are 68. The question is not agreed to. The question is that Kahurangi Kāta's Part 3 amendments to Amendment Paper number 354 set out on Amendment Paper number 366 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
12 votes in favour.
Act New Zealand,
11 votes opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
5 votes in favour.
The ayes are 51, the noes are 68. The question is not agreed to. The question is that the Honourable Karen Shaw's amendment set out in Amendment Paper number 354 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Widow Jean Prime's tabled amendment to Clause 17 brackets 4, amending the definition of authorised person in Section 384A be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
12 votes in favour.
Act New Zealand,
11 opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
Yeah, I thought so.
The ayes are 46, the noes are 68. The question is not agreed to. The question is that Kahurangi Kāta's amendments set out on Amendment Paper number 369 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
12 votes in favour.
Act New Zealand,
11 opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
5 votes in favour.
The ayes are 51, the noes are 68. The question is not agreed to. The question is that Kahurangi Kāta's amendments set out on Amendment Paper number 370 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National,
49 votes opposed.
New Zealand Labour,
34 votes in favour.
Green Party of Aotearoa, New Zealand,
12 votes in favour.
Act New Zealand,
11 votes opposed.
New Zealand First,
8 votes opposed.
Te Pāti Māori,
5 votes in favour.
The ayes are 51, the noes are 68. Sorry, the question is not agreed to. The question is that will Agenda Prime's tabled amendment to clause 24, inserting subsection 1A into section 304H be agreed to? All those in favour say aye. Aye. To the contrary, no. Aye. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour, opposed, sorry.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
12 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 48, the noes are 68. The question... Sorry. The ayes are 46, the noes are 68. The question is not agreed to. The question is that will Agenda Prime's tabled amendment to clause 25, inserting subsection 1A into section 3841 be agreed to? All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
12 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 46, the noes are 68. The question is not agreed to. The question is that will Agenda Prime's tabled amendments to clause 28, inserting subsection 1 AAA into section 384 KB be agreed to? All those in favour say aye. Aye. To the contrary, no. Aye. The noes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
12 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 46, the noes are 68. The question is not agreed to. The question is that Kahurangi Carter's amendments set out on amendment paper 371 be agreed to. All those in favour say aye. Aye. To the contrary, no. Aye. The noes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
13 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 47, the noes are 68. The question is not agreed to. The question is that will Agenda Prime's tabled amendments to clause 28, amending new section 304 KK be agreed to? All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
12 votes in favour. Sorry. 13 votes in favour. Changeable.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
The ayes are 47, the noes are 68. The question is not agreed to. The question is that part 3 as amended stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Now we come to debate on part 4. This is the debate on clauses 32 to 35, amendments to Public Records Act 2005. The question is that part 4 stand part.
Mr Chair.
The Honourable Karen Troll.
Thank you, Mr Chair. So it's a privilege to be able to stand here on behalf of the Minister responsible for this part of the legislation around improving public records and the record keeping in response to the Royal Commission of Inquiry into Abuse in Care. So Part 4 deals with amendments to the Public Records Act 2005. Whilst this may seem like a small change, Mr. Chair, the changes to allow the Chief Archivist to audit an agency more frequently where required and allow the Chief Archivist to work with agencies to put in place action plans and to issue performance notices to improve practice. This will make a big difference to the lives of people who are care experienced. This is something that's close to my heart, knowing that children, especially focusing on children, that have gone through the system from a very young age and have been part of the system most of their life. Each page of documentation, each entry around what has happened in their lives is a page in their story. And they have a right and deserve to be able to see their story, understand their story, and digest their story in a way that they want to. And having to beg, chase, and often fight for those pages that make up our life and make up the story and the journey that they've been through, going through a care system, is highly inappropriate and quite disgusting in some circumstances. We need to make sure that we give back the power to people who have been through the system and people who are care experienced to own their life and own their story on their terms. So anything that we can do to improve this, bring some more accountability into this space, speed up the process, and actually make sure that we're doing the right thing to help people reflect on their history, heal in their present, and empower their future is a good thing. Thank you, Mr. Chair.
Thank you, Mr. Chair. And as we head toward the end of our engagement with this bill, our thanks again from this side of the House to the Minister for her really robust responses to questions, which we found very helpful. I would say that we continue to believe that transformation is needed in this space. It's certainly what we're hearing from those who've been through the system thus far and from those who represent them, that more needs to be done. And so we look forward to ongoing discussions with the government. I do believe this is an area that will require all sides of the House to work together in harmony as we continue on this journey. I have a question in relation to a change proposed to the Public Records Act. So I am looking at new section 34, and there are two issues I have here. So the current section 33 of the Act, which is the independent audits of public office, require that audits must be conducted of the data kept at an interval of not less than 5 years and not more than 10 years. And the amendment removes that time period and changes the language so that it's just as directed by the Chief Archivist. And I'm wondering what the rationale for removing that time period was. The second issue is around independence. The current section under the Public Records Act requires an independent commissioning of that review. The changes allow the review to be, or the audit to be carried out by an employee of the department or or another person engaged by the archivist. And I wonder if there are budget issues here. So the section in the current Act specifies that the archivist must carry the budget for those audits, and I wonder if by making this change we're solving a budget problem but potentially not the independence issue which the legislation as it's currently drafted protects. I wholeheartedly agree with the Minister that the keeping of data is critical in terms of really giving justice to the people concerned. So on the issue of timing and on the issue of independence, I'd really appreciate the Minister's response.
Glenn Bennett.
Good, Mr. Chair, and again I want to reiterate my colleagues' thanks to the Minister for her free and frank engagement this morning. It's much appreciated, and I know that people whose lives are impacted by this appreciate it also. And my second, I guess, just brief thanks is around Part 4, and you made it very clear, Minister. And for me, my own family, one of my parents came from a different time when the records of their early life were long since destroyed and burnt, and so it's paramount that we protect and guard. As you said, Minister, these are people's stories, and I look from many decades ago to only in the last 2 decades, and young people in my care and the ability to access parts of their story. And so I just want to seek reassurance. I feel like you have answered it, but just I guess I wouldn't be able to leave the house today and go back into my community, into my home, to make sure that everything will be available to a young person who has been in care. But secondly, I wonder if there's any way within this, and I haven't put an amendment on the table, it's around plain language, because I know that at one stage a young person who received their what was SIF's history back in the day, but a lot of it was hard to understand. Is there any ability to ensure that plain language can be included in this piece of legislation?
No other questions? Do you want to take the
Mr. Chair, sorry. I just want to answer the question in regards to the new section 34. The advice here says that this allows for faster re-audits to check up on agency record keeping. The chief archivist has is statutorily independent, as would be looking at those audits, and the budget available for the audits is not changing.
Just no?
Going to mow the debate and this now closed.
We were going to. That's right. The question is that Part 4 stand part. All those in favour say aye. To the contrary, no. The ayes have it. The question is that Schedule 1 stand part. All those in favour say aye. To the contrary, no. The ayes have it. Schedule 2. The question is that Schedule 2 stand part. All those in favour say aye. To the contrary, no. The ayes have it. That was out of order. Sorry. Hold a sec.
Switch out.
Cool. Kahurangi Carter's Schedule 3 Amendment to Amendment Paper number 354, set out on Amendment Paper number 366, is out of order as being inconsistent with the previous decision on the committee. The question is that Schedule 3 stand part. All those in favour say aye. To the contrary, no. The ayes have it. Members, we now come to our final debate, Clauses 1 and 2. This is the debate on Clauses 1 and 2, title and commencement. Glenn Bennett.
Kia ora, Mr. Chair, and just a final contribution from the Labour caucus this morning is that there are some things that we would have liked to have seen amended, but in the whole we support the progress of this legislation, and thank you for the engagement of ministers. Really, that's all I have to say, because I think it's time for us to move forward, and I think to be collegial in this. So we support what the ministers have presented, and I say, as we'd like to have seen a few changes, and we will continue to support moving forwards so that we can continue to address the harm and ensure it never happens again.
The question is that Clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Clause 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. I will report this bill with amendment.
The House is resumed.
Madam Speaker, the committee has considered the Responding to Abuse and Care Legislation Amendment Bill and reports it with amendment. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. This bill is set down for third reading next sitting day. I call on Government Order of the Day number 2. Just one moment, Minister Watts. We've just got a couple of little things to take care of.
Marine and Coastal Area Takatai Moana Customary Marine Title Amendment Bill, second reading.
Honourable Simon Watts.
Madam Speaker, I present a legislative statement on the Marine and Coastal Area Tutaki Moana Customary Marine Title Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website. Honourable Simon Watts.
Madam Speaker, I move that the Marine and Coastal Area Tutaki Moana Customary Marine Title Amendment Bill be now read a second time. Madam Speaker, the Marine and Coastal Area Act was established in 2011 as a regime for managing interests in the foreshore and seabed that carefully balanced the recognition of Maori groups' customary rights with the legitimate interests of all New Zealanders. One way customary interests are recognised under the Act is through the award of a customary marine title. CMT. CMT comes with valuable rights. These include the ownership of non-Crown minerals, involvement in planning, and the ability to permit or decline certain resource consent applications. CMT also provides holders with the right to be engaged with when new significant infrastructure is proposed. These rights were included in the 2011 legislation on the basis that the test for CMT was exacting and recognise CMT only where customary interests have been maintained with sufficient strength right through to the present day. However, in 2023, the Court of Appeal interpreted the CMT test in a way that significantly reduced the need for continuity and exclusivity in the scope of what can constitute a substantial interruption. I respect the role of the courts as one decision maker under this regime and the challenge in interpreting the CMT test in the context of the wider Act. But for this regime to work as Parliament intended, a rigorous test for CMT needs to be maintained. The Government believes that the Act was and is a strong affirmation of Parliament's role to achieve fairness for all those that have interest in coastal areas. The Justice Committee reported the bill back in December of last year, and I will discuss the committee's work in a moment. But as members will be aware, the Supreme Court delivered a judgment also in December last year directly relevant to the test for customary marine title in a case called Re Edwards. The sensible thing to do in these unusual circumstances was to take time to carefully consider the Supreme Court judgment and its implications for the bill, and that is what we have done. Let me say it is a helpful judgment. The Supreme Court confirmed that the Government was right to have concerns about how the 2023 Court of Appeal Re Edwards decision approached the customary marine title test. As the Supreme Court noted, the Act aims to balance a wide range of interests in the common marine and coastal area. However, that does not mean that the Supreme Court judgment substantially fixed the difficulty with the previous court decisions or restored the balance of interest. Following the Supreme Court's December judgment, the High Court issued a decision that have made extensive findings of CMT, illustrating that the Supreme Court's test has not altered the approach of the courts in practice. Parliament clearly did not intend CMT would be available at that scale. So to resolve Parliament's intent, legislative clarification is still required. The bill provides the necessary clarification because it goes further than the Supreme Court in crucial ways, including more tightly defining what exclusive use and occupation means, requiring the courts to base any inferences on firm physical evidence, not on cultural association alone, and placing the burden of proof more squarely on applicants. As members will be aware, the Supreme Court has recently issued a second judgment in re Edwards. That judgment has limited relevance for the bill, although it does raise some broader issues about the beds of navigable rivers which the government is still considering. I will now return back to the work of the Justice Committee. I wish to thank the Chairperson, James Mega, and members of the committee for their efforts, including hearing a large number of submissions under demanding time frames. It was good to see that submissions came from a wide range of submitters, including current CMT applicants, other groups and members of the public. I would like to extend my thanks to those who participated and made valuable contributions in that select committee process. The Justice Committee's report proposes mainly clarifications around technical drafting amendments, and I am glad to see that the committee confirmed the substance of the bill. The most notable amendment proposed by the committee responds to a theme of submissions. It relates to how the bill's amendments prevail over other law. The scope of this overriding effect provision has been confirmed in the committee's proposed amendments to refer to the purpose of the treaty sections of the Principal Act and relevant judgments. This is shown in the proposed new subsection 3 for new section 9B. Part 2 of the bill outlines the specific aspects of the law that are to be altered by the bill and the parts of court judgments that are being expressly altered or overridden. The committee has not proposed any changes to this part of the bill. However, as I have said, the courts have issued further decisions since the bill was introduced, so this part will need to be updated. To do so, I intend to table an amendment paper during the upcoming Committee of the Whole phase of the House. I acknowledge that some submitters raise concerns about the retrospective elements of the bill in Schedule 1AA. The schedule provides that CMT decisions after the date of the announcement of this policy, that is, from the 25th of July 2024, will be on the basis of the amended test, and any CMT decisions made in the interim period between the policy announcements and enactment will be overturned by Clause 4 of the new schedule and reheard under the amended test. This will require rehearing 7 cases, including 4 where customary marine title has already been recognised. In the government's view, retrospectively applying the amendment test is necessary to have as many applicants as possible decided under a test that appropriately captures Parliament's original intent. Recognising the impact this will have for the affected applicants, the government has approved $15 million to help meet their rehearing costs. In conclusion, Mr Speaker, now the bill has been reported back and ministers have considered the Supreme Court judgment, the government intends to progress the bill to enactment without delay. A further adjustment will be required before third reading. To do so, I will introduce an amendment paper on the bill at the Committee of the Whole stage. The amendment paper is required to address the Court's judgments issued since the bill was introduced, clarify that changes to the CMT test do not apply to ngā hapu o ngā poru, as their bespoke legislation is based on prior agreements with the Crown, and address one outstanding issue about the kinds of activities that can cause substantial interruption of CMT. Mr Speaker, I commend the bill to the House.
The question is that the motion be agreed to. The Honourable Peony Hanare.
Mr. Speaker, and I want to put on the record that we oppose this bill, and we do so in light of the Minister's words just now. We can't look at this particular bill in isolation. The Minister has made it very clear, and this government have made it very clear about their willingness and their policy to exploit the minerals of Te Takutai Moana, and the Minister has just confirmed that. And this is simply easing the way, even more so for this government, to just ram through their policy and run ahead with what they see fit. Mr. Speaker, yesterday in the House, the member, Mr. Ferris, asked a very good question of the Minister, and that was, what does he say to the private landowners who own parcels of land all around this country that actually deny access to the beach? And the Minister's flippant comment, I'm hoping it was flippant, but it certainly wasn't well received. He said, get on a boat. Jump on a boat and you can go around and access it by the ocean. Now, Mr. McCullum, who's in the House, is the member for Northland, who knows many of those parcels of land across Te Tai Tokerau, where those landowners, the majority of them, Pākehā, non-Māori, who stop access to the beach. They do. They do. And I know where that is. And if anyone knows where Waimahana is in the far north, when you get to the ridge before you look down to the left on Waimahana, have a look to the right. There's a place called Paradise Bay where you can't get to. And the Minister says, jump on a boat. So I'm going to encourage all of my whanaunga. According to the Minister, get on your waka, go and visit those parcels of beaches and those takutai moana right across Te Tai Tokerau and express your views to the landowners there and say, it's okay, because the Minister said, jump on your waka, and that's what we're going to do. So, Mr. Speaker, I'm really upset at the way that the Minister in his speech just now characterised how it wasn't the intention of this House at the passing of this bill in 2011. Christopher Luxon, a man who is well respected right across this House and indeed across the country, and he already spoke, the Minister already spoke to the bespoke legislation with Ngāti Pro. Minister Luxon did that work. And former Minister Luxon, was very clear to this government that what they're doing to this bill is abhorrent. And it actually isn't what he did when he passed this bill in 2011. And I want to remind the House that that bill was carefully negotiated between the Māori Party and the National Party of the day. And Mr. Luxon is very clear that what this government doing is wrong. Now, the government's just spoken to something that I know in this House we seldom use. One of those kaupapa is retrospective legislation. It is one of those avenues where we warn members of the House long before my time here, and I'm sure into the future, that you use retrospective legislation or the reach of retrospective legislation very rarely. And in only very few circumstances has that happened. I've been here in the House when that's been used before. Now we're saying, not only are we going to change the rules while everyone's playing the game, but we're going to push you all back to the start line. Why does this sound familiar to our people in the House here? That's what they did on equity, pay equity. It's the same thing. We're going to change the law and we're going to push everyone back to the start. Just because of a case where the judge and the courts found actually in favour of customary title. And for anybody who's been through the process of proving either customary title or any kaupapa through a settlement, the proof of burden rests with the iwi, rests with the hapu, rests with the whānau, rests with the claimants. And I can say to this House that that proof of burden is extremely high. And it takes years and years for that evidence to be built and for that case to be brought in front of the court. Once it gets to the court made a decision, and this government is saying, oh no, that's not good enough, we're going to change the law. We're going to go back to what it was actually intended. Well, the person who passed the bill was clear on what it was intended, what was intended when he passed that bill. Now we have a change from this government, but we're not surprised. We're not surprised. And, you know, we've got a number of treaty settlements coming up in this House, and we want to remind the whānau out there that this particular bill doesn't sit in isolation from all of those that are currently pushing their bills through this House. And we're going to remind this government of that, because often on those bills we stand in this House and we talk about unity across the House. Well, right now, Mr. Speaker, that's clearly not happening. Labor opposes this bill for the matters of retrospectivity, for the matters that the Minister has raised about their push and their policy to exploit the minerals at the government's will. We also oppose it because what we know about this particular bill is when the Minister introduced it last year, 1 year ago, he said it was going to be passed quickly. Then he learned a solid lesson that you actually have to talk to the people who it affects the most. So it's taken a year and we're back here. Now the Minister is saying that it's going to pass again. It'll still pass before Christmas, a year after it was first introduced in this House. Now, usually in this House, we're slating the government on the fact that they truncate all of the processes on important bills that matter to New Zealanders. Now, what we have here is the Minister learned his lesson. He introduced the bill this time last year and then went, oh heck, I might have bit off more than I could chew. And now we're back here a year later, and guess what? What I heard from the Minister in his second reading speech, nothing's changed. And all of those people that submitted, and it's very clear, some very powerful people submitted, legal experts, those who are in the know, iwi and others who have gone through this journey, who submitted on this bill, the government is still not prepared to listen, and it's still not prepared to alter its view on this particular matter. Mr. Speaker, we are really disappointed that this particular bill continues to strip away rights, and what we're asking for on this side of the House with the Labour Party is, actually, we have a right to prove that case in court. And once we did, wow, guess what? The rules have changed again. And for all of those whānau out there, all of those hapu, all of those iwi who have been through this process will know just how hard this is going to be from here on out because of this bill. And it is unjust and it is unfair. It is grossly unfair that the government, at the will of their policies, at the will, dare I say it, of many of their backers, push a bill like this through the House simply because they are unhappy with the judgment from the court. Now, I recognise that Parliament can make legislation. Courts, and it's their job, is to interpret it. But what I don't and I can't stand for is when this government and this Parliament stands up and says, oh, we're not happy with the court, so we're going to change it. So we've got to ask ourselves, are there other pieces of legislation that the government might look at simply because they don't agree with a judgment from the court? Yeah, no, it is. And that's why we've got to respect that. Now, the member on that side of the House said that's the role of Parliament. I just said that. This bill was passed in 2011 by a man well respected in this House who actually negotiated a very good bill. And this government is now changing it simply because they're not happy with what the courts have said. Now, that member, I know for a fact, has never been to the court to prove a customary title. I know for a fact he hasn't. Well, guess what? You're looking at somebody who has. You're looking at a tribe and a person who has been through that process. So that member can chirp all he wants, and I look forward to hearing what he has to say when it comes to his party's call on this bill. Because I can tell that member, when the ACT Party get up in this House and talk about treaty settlement bills, we're all going to sit here and go two-faced, because that's what that is. That's what that is. So that member knows that this House can make law. But this government has proven time and time again they've blurred the lines between the courts and this House. And they continue to do it, and they do it again on this bill. That member sits there and shakes his head, but he is incorrect when he thinks that we are the ultimate lawmaker here. Yes, we are. However, the courts have the opportunity to define that. Why? Because people take their case to the court. And that member doesn't know what he's talking about. So, Mr. Speaker, just in the final minute, we want to be very clear that we've heard the amendments that the Minister has offered for the Committee of the Whole. We're going to offer some amendments, and I can guarantee we're going to prosecute those matters when it comes to the Committee of the Whole. It's clear that this government haven't heard from those who have submitted. They've clearly just listened to them and done nothing about it. Momo timer, waste of time. And they wonder why the public out there have no confidence and no faith in what this government is doing. Because once again, we've got a government who thinks they know best. They know best. They know better than the legal profession, they know better than the courts, and they know better than those who have had customary title and will once again show this government where it's at.
Steve Abel.
Thank you, Mr. Speaker. I visited a thing called the Anaweka Waka in Golden Bay about a year ago. It is quite a profound thing to see directly in person, Mr. Speaker. It is a 700-year-old sailing waka found at the top of the South Island on a beach. It is a moving experience to see what we all know is the history of these lands, that the tupuna of tangata whenua Māori sailed that vast ocean of Te Moana Nui a Kiwa to arrive here in these lands. And for most of the last 1,000 years, they have circumnavigated and sailed and gone through the harbours and the inlets and up and down the estuaries, and they have built their homes and their rohi, and they have interacted with the takutai moana, the marine coastal environment. It is a simple fact of history. I have seen the timber waka that is 700 years old. And yet we seem to be here questioning whether Māori have customary use of the marine coastal environment. How ludicrous. What a preposterous thing to be contending. That is the starting point for how ridiculous it is to find ourselves in this situation. And yet, there was effective confiscation of that marine coastal environment. If we as a parliament, as a nation, believe in the intention of settlement to recognise a wrong and make amends for it, and the highest principle should surely be justice. And we know why justice is important, because of rapprochement, because of the establishment and the resumption of harmonious relations. Anyone who thinks there can be a cohesion or a lasting contentment in our nation for any of us without upholding and making good on the dignity and the intent of that founding agreement, Mr. Speaker, Te Tiriti o Waitangi, is a fool, frankly. This bill is the most anti-treaty act of this government. Far worse than the Treaty Principles Bill, only because it will pass. It will affect confiscation. Where Seymour failed to clumsily rewrite our founding agreement, this bill undoes a settled pathway for rapprochement, for settlement. And therefore, it is fundamentally an anti-New Zealand bill. The 2011 correction of the confiscation of the foreshore and seabed that was affected by the Marine and Coastal Area Act was achieved by agreement across the House. There was an agreement that a wrong was done. Labor realised the error of their approach, and a markedly more visionary national government than this one before us, in coalition with Te Pāti Māori, brought a mechanism for recognition of Māori customary rights to the takutai moana, the restoration of the right of Māori to go to court, a basic common law right. Even the ACT Party at the time thought it was a travesty that that right had ever been removed. But this bill retrospectively cancels that right for all the claimants who have already been or in the process of going to court. Basically, Māori went to court, won in court, and the government went, oh, hang on a minute, we can't have that. We better fix it and undo it. That's what this bill does. It sets the bar so high as to dissuade any other iwi from wasting their time and money on that court process. It rips up that cross-party agreement, and frankly, Mr. Speaker, it stabs Māori in the back once again. It exists in that long and tawdry tradition of crown betrayals of iwi Māori, and it is as such a restoration of the raupatu of 2004. It is anti-New Zealand, Mr. Speaker, because if our objective is rapprochement, harmonious relations, this commits a treachery against that founding relationship. It has a constitutionally treasonous character because it betrays the intent of the mutual agreement which formally brought the nation of New Zealand into existence. an agreement between two sovereign entities, the rangatira of Te Iwi Māori and the British Crown. This bill is in the tradition of traitorous Crown betrayals of Māori and that founding agreement, the very tradition we are trying to correct through the settlement process. This is exactly the laws that we apologise for when we do the settlements. It renders those present-day settlements as a true duplicity. The government gives back a little of what was stolen with one hand and steals even more with the other. That is what this bill today does. It is kupapa kawanatanga. It is perfidious Albion, Mr. Speaker. Duplicitous Britain. Perfidious Albion refers to acts of diplomatic slights, duplicity, treachery, and hence infidelity with respect to promises made or alliances formed with other nation states. The promise of Te Tiriti o Waitangi to uphold tino rangatiratanga and the sovereignty of Māori is broken by this bill. The alliance formed in the founding of our nation through that agreement is betrayed by this bill. It is perfidious Albion, Mr. Speaker, the character of constitutional treason. The Minister resurrects the darkest tradition of Crown betrayal, evokes the tradition of colonial theft. And should we be surprised because that particular Minister believes colonisation was a good thing for iwi Māori? So surely doing more colonisation would be good in his estimations. Well, this bill does that, and he is deeply wrong in that. The view of this bill from a government that purportedly has a property rights ideology, in so much as it believes they can manage the commons, the rivers, the lakes, the aquifers, the oceans, the atmosphere, through private property rights, yet they don't uphold the first property rights of this country, Māori customary rights. And they're diminishing those rights across the vast acreage of the marine coastal environment today. They don't really believe in property rights, they believe in the right to accumulation of capital of those who would exploit nature. In fact, as with the environment, they see protecting the commons and upholding Māori customary rights and treaty rights as a barrier to the commercial exploitation of the environment, as the Minister has said as much in his recent statements on opposing tikanga components of law because they were a barrier to business. Justifying opposing the logical plurality of our legal system, upholding both tikanga and common law as consistent with the treaty. Every legal system is bespoke, Mr. Speaker, of course. Every country has its own sets of laws and established jurisprudence. The idea that Parliament intent has been restored by this is absolute garbage, and if you have any doubt, you could simply ask the author of the original Marine and Coastal Area Act. He's still alive, he's still around, he's speaking at the Waitangi Tribunal commemorations right now. Is it any accident that this bill comes before the House on the 50th anniversary of the creation of the Waitangi Tribunal? I would love to say it was an accident. Mr. Christopher Luxon, who wrote this bill, the former Attorney General, put it plainly: these amendments do not restore the original intent of Parliament, they undermine them. Let there be no doubt about that at all. Mr. Speaker, I marched across the Auckland Harbour Bridge in 2004 against the Foreshore and Seabed Act. My parliamentary forebears stood with an Honour Te Tiriti banner on these steps in 2004 as the throng of the Hikoi arrived, and that banner said, "Honour the treaty." And this Green Caucus here stood on the steps again with that massive treaty met us at Parliament last year with the same message of honour the treaty. We stand for the principle of rapprochement. We stand for upholding that founding agreement for the good of all New Zealanders, Mr. Speaker. This wretched bill will be the first bill on the repeal list of things that we will do to uphold Te Tiriti o Waitangi when there is a change of government in 1 year's time, Mr. Speaker. Kia ora.
Todd Stevenson.
I rise to take a call on the Marine and Coastal Area Amendment Bill. Look, I see things, there's been a lot of kind of rhetoric across the House this morning. I see things slightly differently, as you might imagine. In 2011, there was a test established for marine customary title. The government is basically, its position is that the Court of Appeal got that wrong. What we want to make sure is that actually the intention of this House is restored. And in fact, the Supreme Court agreed that the Court of Appeal got that wrong. And so what we are simply doing is making sure it's very clear what the customary title test should be. And that's why I commend this bill to the House.
Jenny Marcroft.
Thank you, Mr. Speaker.
Jenny Marcroft.
Mr. Speaker. Thank you, Mr. Speaker. I rise on behalf of New Zealand First in support of the Marine and Coastal Area Takutai Moana Customary Marine Title Amendment Bill. Mr. Speaker, the Justice Committee, and I acknowledge the Chair, the Honourable James Meagher, received and considered submissions from 6,692 interested groups and individuals and heard oral evidence from 69 submitters. Customary marine title was established under the Marine and Coastal Area Takutai Moana Act 2011, and it replaced that very controversial Foreshore and Seabed Act 2004. Mr. Speaker, a customary marine title cannot be sold and public access is maintained. The test for the customary marine title is primarily contained in Section 58(1) of the Act and has two limbs. It provides that customary marine title exists in a specified area of the common marine and coastal area if the applicant group holds the specified area in accordance with tikanga and has either exclusively used and occupied the area from 1840 to the present day without substantial interruption, or has received it at any time after 1840 through a customary transfer in accordance with Section 58(3). In 2023, the Court of Appeal interpreted provisions of the Act about the requirements for recognising customary marine title, which materially reduced the threshold of the continuous exclusive use. New Zealand First believes the Court's interpretation fails to give effect to the intended requirement that applicants for customary marine title must prove they have exclusively used and occupied the area from 1840 to the present day without substantial interruption. So this bill, Mr. Speaker, aims to reduce the ambiguity of the test for customary marine title. It will amend the 2011 Act to provide much more clarity and certainty around how customary marine titles are determined, particularly in response to recent legal judgments re Edwards that have created some confusion, some ambiguity about Parliament's original intent. Mr. Speaker, this bill fulfills a coalition agreement between New Zealand First and National. We believe these changes address New Zealand First's focus on the sovereignty of Parliament and on fairness and transparency in legal processes. It'll balance the natural expectations of all New Zealanders to have an interest in what occurs in the coastal marine space, balancing that with Māori customary marine title, which grants their own valuable rights. My colleague, Mr. Speaker, the Honourable Shane Jones, has stated that recent court decisions have made the test for customary marine title too easy, and that rights creep could enable iwi to obstruct critical development projects such as ports. Rights creep that threatens the economy. Mr. Speaker, seeking to restore that higher threshold for customary marine title being granted. This amendment bill aims to restore the original higher test for customary marine title set in 2011. I commend this bill to the House.
Takuta Ferris. No, Takuta Ferris. It is.
you going to take the next one? Yeah. All right. Tēnā koe te pika. Tēnei kāwanatanga. He kaia te kuri upoko kōhua I roto I enei tuāhuatanga. Enei mahi tūkino whānako e kore whakaitia, e kore tautokona, e te iwi Māori, kaua ko te Pāti Māori. I've just been at the celebration of the 50 years of the Waitangi Tribunal. This is being talked about. But I'm going to take this time to just set the record straight for our whānau at home, because this is a take that has to land at home. At te whānau, you have to get up and make sure that this thing doesn't go anywhere. So in 2004, there was an act by a parliament led by the Helen Clark Labour-led government. Okay, they enacted a piece of legislation that they were warned not to. Their courts told them not to. The UN told them not to. Their treaty partner told them not to. They just arrogantly bowled ahead and did it. And they confiscated, okay, without authority, 336,000 square kilometres of Māori land. The test that had to be proven was there legislation that had actively extinguished that Māori right before 2004? And the answer was no, there was not. So the right into Tiriti o Waitangi was still there when they passed the legislation. That's number one. That led to the rise of Te Pāti Māori. Why? Tariana Turia left the Labour Party because the voice of the Māori seat that she held wasn't recognised. Its independence was stifled, its voice was ignored. She left to assert the independence of those seats. Why? So that we could protect these things. That's part two. The biggest contemporary theft confiscation of land to Tiriti o Waitangi rights land happened in 2004, whānau. Not 1904, not 1804, 2004. And the Māori Party came about and they had to fight that battle for 7 more years until they got into government with the Ki-led national government and agreed to a middle ground, which wasn't a fix or an addressing of the 2004 debacle. It was a band-aid for it. All the while knowing it would continue on into the future as it has. 2017, things happen, there are cases go through, we get to this government, the Luxon-led national government, and they don't like the band-aid that was put on in 2011, they're ripping it off and taking everything with it at te whānau. This is for the public of New Zealand. Okay, because if you listen here to what these guys are saying, they're not even telling you half the story. They're a waste of time. They're not in the debate. So, here we go. The Takutai Moana Act was a band-aid. Okay, and the removal, kia ora, Minister, grab a seat, have a listen. So the band-aid is being pulled off. There are about 6 or 7 other iwi and hapu that have got across the threshold that, although they say it wasn't good enough, they said it. They set it. And Māori did the work like we have for 21 years to prove it. We're proving a right that we didn't have to prove because it was there in 2004 and an arrogant government took it away. That's all this is. And here we are having to deal with it again. Well, good luck with all of the tribunal. Good luck with all of the legal precedent that's already there. Good luck with your courts because they are pushing back on you. You will not succeed. So, Ngāti Kere, my hapu from the puku of Kahungunu are one of those hapu that achieved the customary title, and now he wants to take it away. My iwi of Ngāti Raukawa, Te Au Ki Te Tonga, one of those iwi that achieved that right, he wants to take it away. All right, they're ready. Hei te pai. It's all wasting your time, public. It's all wasting your money, wasting your time, wasting everybody's everything. I'm going to finish by saying this. These are the words, actually, to the public. Who would you rather have look after the interests of the coast? Māori or the liberal corporates over there? Think about that. This is what Justin Tipa, the chairman of Ngāi Tahu, had to say. Let's be clear. This is not about recognising the legitimate rights of all New Zealanders. This is about removing the legitimate rights of Māori. we do not support the bill at all.
Huhana Linden.
Tēnā koe, Mr. Speaker. I rise on behalf of Te Rōpū Kākāriki and in support of my colleague Steve Abel. We absolutely oppose this legislation because like a thief in the night, this government comes through with this legislation that will raupatu, the biggest raupatu that Māori will suffer to our mana taku tai moana. Because what was the issue? What was the problem that this government is seeking to change and improve? There was no need. Māori have been here, mai rāno. We are intergenerational. We were here yesterday, we're here today, and we'll be here tomorrow. Our tūpuna, our people have paddled, have harvested, and lived on these waters for generations. And yet we have a kāwanatanga that is turning its back on the very Māori Crown relationships that have been tenuous for the last 2 years, now tearing it up. You're tearing up Māori Crown relations. We should be celebrating today 50 years of the Waitangi Tribunal. Oreni kaipara coming into the House. We should be celebrating, but instead we're here fighting against a legislation that is the biggest raupatu against te iwi Māori in the history of Aotearoa, because this is an uncaring government. This government cares more of the property rights of Pākehā than the Māori. Why can't Māori have property rights? Why can't Māori have some customary rights to our taku tai moana? When my rangatira from Ngāti Wai yells at this House and affirms that we did not cede our sovereignty, e tikana, e kore e riro. We will not stop fighting this government that continues to hama us as te iwi Māori who have been here mai rāno. That's the crime. That is the shame. That is the mahi apo, the greed of this government that turns its back on its customary partners here who signed Te Tiriti o Waitangi in good faith. At no time did our tūpuna who signed Te Tiriti think that we would be left pohara, that we would be left destitute, that we would lose our mana taku tai moana, because we signed it in good faith. We have a government that is stripping Māori rights. Our communities are exhausted. It's been 2 years of submissions. It's been 2 years of waving a flag, of hikoi, protests. Our kaimahi are going to strike again on the 23rd of October. We will stand to whakamana te tiriti on the 28th of October. And it's tuakana he whakaputanga. This government has no care for te iwi Māori. Our rights are intergenerational, and this government seeks to raupatu, to confiscate those rights that are intergenerational for our people. I cried this morning at Te Herenga Waka as we stood and we looked at the 50 years of delivery, of listening and hearing our people in the Waitangi Tribunal. Those judges, those kaiwhakawa, those legal counsel who have supported us for the ability to bring truth to Aotearoa, that a record would show that there is research that affirms the raupatu that has happened on the whenua. Now we have a raupatu on the papa moana. How dare you? How dare you do this to our people? At such a time when we are already at risk, we are trying to put food on the table. Our people don't know that this legislation is back. We're just trying to survive. We're just trying to be claimants in a process that was not designed for us. The claimant burden of having to go back to the courts again. Do you even understand the 18 weeks of hearings that the tribes of Whangarei had to stand, prepare our elders, get our research, do all of the bling and mapping, all of these thresholds set by the Crown? We met the rule of law. We presented our evidence, and we're waiting for a judgment? And now you're saying, oh no, Māori, no, sorry to the hapua whangarei. You've got to go back and do it again. He mahi pō he. E taka hi ana te mana o ngā hapu o whangarei. Ki te ngāna koutou I te rangatira o Ngāti Wai, e karawhiu ana I tōna rika ki rungi a koutou, nā wai e teka. Nā wai e teka kei a koutou te mana ki te tāhai I tō tātou mana papa moana. Ki hai te iwi Māori e tuku tō tātou rangatiratanga I te waihaina tia te tiriti o Waitangi, kore rawa te Māori e tuku I tōna rangatiratanga I tēnei wā tonu. He mahi pō he, he kāwanatanga apo, he kāwanatanga tāhai. Tūturu whakamaua kia tina e tātou mā. No way will Te Iwi Māori stand for this, and you have torn up any Māori Crown relationship that we will have moving forward.
Carl Bates.
Thank you, Mr. Speaker. Mr. Speaker, this amendment bill is important in order to provide clarity on Parliament's original intent. It is the Parliament of New Zealand that sets the laws of this land, Mr. Speaker, and this inserts a statutory declaration that overturns the court's reasoning and ensures the intent of this House is clear, and therefore I commend this bill to the House.
Shannon Halbert.
Thank you, Mr. Speaker. Rapua te huarahi whānui hei ara whakapiri i ngā iwi e rua I runga I te whakaaro kotahi. Mr. Speaker, I stand before this House after observing an interaction just before that makes me quite sad. I come from a school of thought where I believe that te tiriti o Waitangi is not only the past of this country, but most of all, it is our future. That together all peoples in this country can come together, and more than that, I believe that at this particular time, no matter who you are, where you are in this beautiful country of ours, you want to be a part of a country that is about kotahitanga, about inclusion, that is about a way forward, and it's about coming together to address the challenges that are in front of us, whether they are short-term, medium-term, or long-term. But I come back to the point that te tiriti or Waitangi is our future, Mr. Speaker. But sadly, that is not what I see before us today. Can I acknowledge our rangatira from Ngāti Wai, who stood up because this kaupapa is sensitive. It brings the grief of decades, of hundreds of years of trauma that people in this country have faced. It takes us backwards, Mr. Speaker. It takes us backwards to a part of this history that we don't want to go back to. And in my own party, we have that black mark, we have that history, mō tātou he. We acknowledge that. But Mr. Speaker, this is not the way forward. In addition to that, as last night together, we all celebrated in the Legislative Chamber 50 years of the Waitangi Tribunal. 50 years. Some would say 50 years of progress. Some would say 50 years of protest. Maybe it's all of those things. But Mr. Speaker, even to have this reading on the order paper this year as we celebrate 50 years, Minister, this is cynical. It is cynical, and under your government, you continue to kick Māori down. This does not make us a stronger country. This does not progress our people, our New Zealand people, and it does not progress Māori alike. This is a cynical move, Mr. Speaker. Absolutely cynical. My second point is to the government member that put an allegation forward against a member of this House that she incited protest from the gallery from one of the rangatira of Ngāti Wai. That is unfair and that is not true, and that is an example of this government being out of touch, not understanding the kaupapa in front of us. But again, the backbench is reflective of their leadership, and that leadership is cynical. It is cynical, it is mean-spirited, and it continues the punch down of our Indigenous people in this country. And every opportunity that I have in this House, I will remind government members of the bad choices that they have made for our country and for Māori alike. Repealing Te Aka Whai Ora, taking us backwards on Māori wards, removing te tiriti from legislation, and I also challenge the members of the Education and Workforce Committee who are doing that under our vocational training legislation and under the tertiary education strategy. But time and time again, Mr. Speaker, I think that this government might take a step back and think, oh, times are challenging for us. New Zealand has question marks about the direction that they're taking our country. The actions that they take are more divisive than ever. But then they do something else. Then they do another thing. And so the Marine and Coastal Area Takutai Moana Bill is just another example. Radio New Zealand, Mr. Speaker, under this headline, when reported, characterised by a blind adherence to pre-existing political commitments at the expense, Mr. Speaker, of whānau, hapu and iwi. Not at the expense of every other New Zealand that lives in our wonderful country, the expense of whānau, hapu and iwi. And Mr. Speaker, that's because this clearly is a breach of te tiriti o Waitangi. It's a dismissal of official advice from the Waitangi Tribunal and the important steps not taken in the development process that's resulted in the Crown breaching the principle of good government. I truly believe we all come to this place to represent people, to represent everyone. And when we do get to become government, that we lead this country in a way forward. And this is simply taking us backwards. Not to consult adequately with tangata whenua, with mana whenua, with iwi, hapu and whānau, to push that through. That is not modern day practice, Mr. Speaker. And that's exactly what the government has done, and this minister in the House today. He has not consulted adequately with Māori. That in itself is a breach of te tiriti o Waitangi. Mr. Speaker, the breach there is the principle of tino rangatiratanga by exercising kāwanatanga over Māori rights and interests in the takutai moana without providing any evidence for one of its key justifications, and namely that the public rights and interests require further protection beyond what is already provided by the Act. The Crown also failed to inform itself of Māori interests. The Crown failed to inform itself of what the Māori interests are. Now, I hope that governments moving forward think about what's best for our country, how they will close the gap of the division that we experienced. And the cynical move, Mr. Speaker, is not the direction that people in Aotearoa are looking for. They want unity, they want kotahitanga, they want access, they want fairness, and they want equality. Mr. Speaker, this is a terrible, terrible slight on this Parliament that we are moving this piece of legislation before the House as we celebrate 50 years of the Waitangi Tribunal. I do not commend this bill to the House.
Tom Rutherford.
Thank you very much, Mr. Speaker. I rise to stand in support of the Marine and Coastal Area Takutai Moana customary marine
English law. The idea of having customary rights which have been created by the behaviours of people across generations is something that crosses across many cultures. It's not unique to Māori, but as Steve Abel said so articulately, the fact of the matter is that Māori have for generations been people of the sea. They have navigated our coastline. They have harvested kai from the estuaries and coasts around us. And they have done that across generations. And yet, what we are seeing now is a confiscation. It is a limiting of that. Once again, this government is by inches encroaching and taking away rights. The minister protests, but he does protest too much because he knows as much as anyone that the bill as it stood, the original piece of legislation, was carefully crafted. And it makes it very clear that to establish customary title, the burden is high. That in fact you have to show that across generations since 1840, you have exercised those rights, because customary rights can be lost through a failure to use them, and they must have been held in a substantially uninterrupted way. And that is the test that was presented to the courts, and the Court of Appeal took one view, but the Attorney General appealed, and the Supreme Court actually took it back. And yet the government presses on with this bill stripping property rights from Māori. And what is worse is that there was an agreement that this House reached with Māori to recognise coastal and marine rights, and Māori in good faith embarked on the process to do that. And as Penny Henare said, the process is arduous. Finding the history, the maps, the oral records, and presenting that in a form which can prove, because the onus is on Māori to prove is onerous, but they did it. And yet, this government is going to strip away conferred rights that the court has actually already recognised. They are going to strip away that retrospectively, and that is a constitutionally abhorrent thing to do. And there is no reason for it. No reason other than keeping their crony mates happy so that they can get the consent they want to exploit coastal areas, whether it be for sand mining, for fishing, for whatever, wind farming, whatever it might be. No, they don't want to go through a proper consents process. They don't want to have to engage with Māori. They don't want to have to act in a way which is consistent with property rights. They want to trammel them. And that is why we won't support this bill. It's a terrible bill, and I can't believe Jenny Marcroft, who usually is so sensible on things affecting Māori, spoke in support of it either. It's a shameful bill, and it's a dark day when we don't protect property rights again.
Mr. Speaker.
Rima Narkle.
Mr. Speaker, I'm grateful for the opportunity to be able to express my thoughts in the second reading of the Marine and Coastal Area Takutai Moana Customary Marine Title Amendment Bill. And Mr. Speaker, I think I need to just, as I've done before when we have members of this House, going beyond to a great extent what we're trying to achieve here. So let's just bring it back to what the main, if we sift through, what the main objective of this bill is. So if we can just go back to 2004, Mr. Speaker, when a destructive, damning bill was passed by the Labor government back then called the Foreshore and Seabed Act of 2004. Yes, I do know, Mr. Duncan Webb. I do know because, yes, I wasn't here back then, but I actually do my research because I love this country. I wasn't born here, but I love it. And I love the people that are in this country as well. So, yes, I do know. And I do know because I've had members, elders of Māoridom talk to me about what happened back then in 2004 and how it broke their hearts. So, yes, I know from that extent, Mr. Duncan Webb. So what happened, Mr. Speaker, was this damning, destructing bill was passed. Along comes a guy named John Key with the National Party and the Māori Party. We worked together in 2011 to pass the Marine and Coastal Area Act. What's happened since then, Mr. Speaker, is a court judgment has decided to go way above and beyond what the intention of this House was when we were restoring things in 2011. They went above and beyond what the intention was, Mr. Speaker. And so what we're doing here is we're going back. We're going back, Mr. Speaker. We're not rewinding. We're going back to what this House intended before this court decision was made. It is wrong. It is actually cynical. And when we're talking about cynical, someone from the other side of the House spoke about cynicism. It's cynicism to work people up into a frenzy when they're not saying what the actual truth is. We're restoring what Parliament's intent was when we were fixing up the brokenness of Māori thanks to the 2004 bill that was passed under that Labour government back then. Mr. Speaker, I commend this bill to the House.
This debate is interrupted and set down for resumption next sitting day. The House stands adjourned until 2 p.m. today.